listening in on the webinar and the live stream. I would say that those of you who are on the webinar, if the audio quality isn't quite where you'd like it to be, you might want to check in on the live stream just for this first presentation. We're sort of working on the audio, so if it's not quite at a good level for you to hear on the webinar, you might want to switch over to the link that was sent out for the live stream. Also, if you're on the webinar, there should be a method for you to send questions via a chat function. You can also send an email straight to the Asylum Help SA account. We have that open and are checking it, so if you have any questions throughout, please feel free to shoot us an email, and we'll bring it up and discuss the question. So with that, I think we'll go ahead and get started. Thank you to our presenters for this first panel introduction, my colleague Sarah Ramey and Sarah Sluska from the Northwest Immigrants' Rights Project.
Hi everyone, welcome. We will be talking in this first hour about how someone requests protection in the United States and what requirements they need to show in order to qualify for asylum, withholding of removal, or protection under the Convention Against Torture. So for adults, there are basically two ways of requesting asylum. The first is affirmatively. That's generally for someone who's never had any contact with immigration in the past. They can file with the U.S. Citizen and Immigration Services Office, and that process is referred to as affirmative. For someone who is in removal proceedings before the immigration court, they would be filing their asylum application with the judge, and that's referred to as a defensive application. Anyone who is scheduled for immigration court will be issued a notice to appear. That's the charging document. And for those of you who are here in person, there is a handout after the presentation slides with a sample copy of the notice to appear. I believed I emailed that out to everyone recently, although I think it might not have attached appropriately. So I apologize for that if it did not, and we'll send that to you here in a little bit. There's basically three ways that people are put into removal proceedings. If you look at the three boxes on the notice to appear, one of those should always be checked in any type of removal proceeding. The first one is for arriving aliens. Those are people who present themselves at the bridge. The second is for people who basically cross the river or the desert without documents and are apprehended here inside of the United States. And the third is for people who, generally speaking, came with a visa, overstayed the visa, maybe living here in San Antonio and get picked up here and then put in removal proceedings. And these distinctions can be very important. So for people who are picked up by immigration outside of the border area, so passing 100 miles from the border, or after having been 14 days here in the United States, they will be directly scheduled to see an immigration judge and placed in 240 removal proceedings. However, people who are picked up within 14 days or within 100 miles of the border are put into what's called expedited removal. And that basically means they don't have the right to see a judge. They'll be sent immediately back to their home country unless they ask for protection. So if they express a fear either to Customs and Border Patrol or in a detention center to an ICE officer, if they express that fear of returning to their home country, they will be scheduled for what's called a credible fear interview. On the second page of the handout, there is a step-by-step guide to what happens for someone who's in removal proceedings who is requesting protection. And once they have requested that protection, they do speak with the asylum office. For us, that would be the Houston Asylum Office. And that officer who's trained specifically in asylum will determine whether or not the individual has a significant possibility of succeeding in their claim if their case goes before an immigration judge. We want to give a little plug for the Raices Carnes Pro Bono project, which works with the detained families at the Carnes, and we also partner as part of CARA with the team that works out at Dilley. And the Carnes Pro Bono Project does several different things. One of those is helping detained mothers and children prepare for their credible fear interview with the Houston Asylum Office. So if anyone is interested in volunteering at the detention center, and we do sometimes have remote work that can be done. I know some of you listening in probably have come down and volunteered, and thank you for that. You can get in contact with Andrea Meza about the opportunities there. Once someone has passed their credible fear interview, hopefully they pass, and they will be scheduled to see an immigration judge. So at that point, they'll be placed in 240 removal proceedings. And what we're going to talk about today is how to prepare their case, or what issues need to be looked at when you're determining if that person qualifies, if that's a case that you might want to take for representation. The panel today will be very basic, this first panel, and then at 1:30 we'll be returning to discuss common fact patterns that we see, in especially Mexican and Central American cases, and case strategies and legal arguments to deal with some of the more complicated issues that come up in those cases. This first panel is intended to go over the basics so that we're all on the same page, and everyone has a solid background. Okay, so basically the main things to look at when you're trying to determine if someone qualifies for asylum, and my colleague Sarah will be talking about withholding of removal and protection of the Convention Against Torture. Right now we're just focused on asylum. And a lot of times people will say they're here for asilo político. It's important to mention that there are other forms of protection to people, whether you're doing a Know Your Rights presentation or whether you're evaluating that case for representation. So for asylum specifically, there are three big things that you want to look at first off. One is the first facing serious harm. Okay, can't just be a little bit of harm. Two, is it for one of the 5 protected grounds? And 3, do they really need protection here in the U.S.? Or can they receive protection in their home country? So first off, you want to look at both past harm and future harm. Especially if it seems like the past harm might not be all that much, it's really important to talk to your clients about what they think might happen if they go back. And people sometimes are uncomfortable with guessing because they don't know, right? That's reasonable. We don't want them to say, oh, this will definitely happen. But they have an idea based on their experience, the community, maybe what happened to other individuals. So there is a very well-developed concept in asylum law of similarly situated individuals. If someone in that similar situation faced a particular type of harm, the probability that your client would increases, right? You also want to look at the level of persecution or the level of harm to determine if it rises to the level of persecution. And so a lot of times people focus on the physical, right? The beatings and other physical mistreatment. You want to also really focus on the emotional harm. Sometimes that's stronger than the physical and can be a ground independently and on its own for protection. The other thing that comes up sometimes is threats. Actually, it comes up often. Someone can receive protection because they've been threatened in the past with no beatings and no necessarily per se emotional harm, although I would say that probably qualifies in most every case as emotional harm. So the case law, there's not a golden rule for this, right? The case law really varies. There's some cases that say multiple times in prison, multiple beatings is not persecution. There's some cases, as I mentioned, that say one death threat is enough to qualify as persecution. There's also some case law that says that if economic harm is really severe, that can qualify as persecution. We don't see this so much in the Central American cases, but I don't see why, if the facts weren't compelling, you couldn't make that argument. And so, do look at that if it seems like you're seeing some economic concerns. If the discrimination is so high that person can't get a job, they can't support themselves, maybe you are at the level of persecution. Now, I often tell people, because people say, oh, I have this big problem, I should get protection. It's not that simple, right? I often tell people that unfortunately, our laws in 2017 are a result of the problems in World War II. And the definition, which is on the presentation, basically that we have in our Asylum Act from 1980, reflects the UN Convention relating to the status of refugees that was redacted in 1950, 1951. So a protection is only for people who face harm because of their race, religion, nationality, membership in a particular social group, or political opinion. And the way that you can think about this is that the person has to be harmed or face future harm because of an immutable characteristic. An immutable characteristic is something that you cannot change, like your race or your nationality, or an immutable characteristic has to be something that you should not be required to change, such as your political opinion or your religion. Membership in a particular social group is basically one of these two things. You have to be a member of a group that you can't leave, either because it's just impossible, because, for example, you're a member of that family and you can't change who your relatives are, or you shouldn't be required to change your membership because it's so fundamental to your identity. One of the examples that I give in most cases, because it seems to work in most countries, is that of homosexual. So I say, if you're a homosexual, you have different gender identity, and you face harm because of that, right? You're recognized in society as being different, you can get protection. And I think it's a clear example. The other reason why I use it is because it helps people who might not otherwise express maybe a different gender identity to come forward and say, hey, yeah, actually that's my case. And we'll give more examples of social groups in the second panel, and also, I think, a little bit in our hypos. So the other thing that's worth keeping in mind is, even though the harm has to be, the persecution has to be because of one of these 5 grounds, it doesn't have to be the main reason the person faces harm, and it doesn't have to be the only reason. So the standard is one central reason, right? It has to be a principal reason, but it doesn't have to be the only, and it doesn't even have to be the most important reason. And I think a lot of times, if you focus on the standard, your cases get a lot easier. So just keep that in mind. Now, asylum protection is really for people who have no other option but to leave their country. So this basically means that the police are unable or unwilling to control the people that are persecuting the individual, or the police themselves or the government are the ones persecuting the individual, right? And it also means that people have to not have any safe place to live in the country. So they can't just say, oh, I have problems in Matamoros with the cartel. If they can go live in Mexico City, if they can go live in Chiapas and not have any problems, they're expected to do that before they're going to be requesting protection in the United States. Now, you don't have to prove this. So from an attorney perspective, it's really important to keep in mind this isn't something you have to prove. You want to prepare for it in your declarations, in your brief, but it's the government's burden to show that internal relocation would be reasonable. And they have to show it would be reasonable under the totality of the circumstances, right? So that's looking at things like age and gender, for example, and they have to show by the preponderance of the evidence. There's also another argument that the government often makes, which is that of changed country conditions. Same thing, the burden is on them to prove changed country conditions by preponderance of the evidence, looking at totality of the circumstances, and it has to be a fundamental change of circumstances. So one of my favorite things, I would say jokes, but the government was completely serious about this, is they decided that Somalia was a safe country for people to go back to because they suddenly had postal service. I would argue that's not a fundamental change. So, really look at that part of the standard. Now, there's also, we will discuss what we call humanitarian asylum in the second panel, but please keep in mind that even if the government has met their burden and has shown internal relocation or is reasonable or has shown there is a fundamental change in country conditions, as long as there was past persecution, so this doesn't work for future fear claims, but as long as there was past persecution, you can still get asylum. You just have to show that the past persecution was really severe. So we're talking about, let's say, the Rwandan genocide, right? And the fact that maybe things are better now and the Tutsis are in power and this person could go back and live there is all very proven, reasonable, etc. That person could still maybe get humanitarian asylum because, let's say, just by being in that country, they're going to be so traumatized because of everything that happened in the past. I think that's a little bit of the logic behind that. But it has to be pretty severe, past persecution. And then the other way is if they would face other serious harm. So, let's say the country conditions are great now and the person could go back, but if they went back, let's say there was a big hurricane. It seems to happen every so often in Central America, and there's no jobs, the infrastructure is destroyed. So they might not have problems with the gangs anymore, but they would face other serious harm, so they could get a humanitarian asylum. So I'm going to transfer the presentation over now to Sarah so she can talk about some bars to asylum. Sarah, are you there?
Thanks. Yeah, can you hear me?
Yes.
Okay, great. So if you meet all the requirements that that Sarah mentioned, other Sarah, there are still some bars to asylum. And so they're all listed on the statute and regulations. And so the first one is the 1-year deadline. And so there's a requirement that you file your Form I-589 within a year of arriving in the United States. And so that tends to be a problem for a lot of people who are released at the border. They're paroled in once they ask for, protection. And a lot of times their court dates are set further out and they don't necessarily, have a lawyer at the time and they're not able to file, or they've come in without inspection and, maybe had a fear of returning, but didn't file and didn't really know about the asylum laws. And so now it's many years later. And so if they're now apprehended, then they often have a problem because of this 1-year deadline. So there are 2 exceptions listed. So the first one is if you can show that there are changed circumstances in your country that materially affect your eligibility. So, for example, if there was a regime change and now things are a lot worse, or, arguably the cartel violence in Mexico got a lot worse over the last few years compared to maybe 10 years ago. So there's some examples of changed circumstances in the country that would affect the eligibility materially. And then the other example is if you can show that there were extraordinary circumstances that were directly related to your delay in filing. And so the regulations at 8 CFR 208.4 lists out a bunch of them, or all the ones that they'll consider. So some of them, for example, are if you had a serious illness or mental or physical disability, including any effects of persecution or violent harm that you suffered in the past during the 1-year period and after arrival, during the 1-year period after arrival. And so you have to show that you were suffering those effects during that 1-year period, and that's why you didn't file. The Asylum Officer Training Manual, which is available online, I think the version that I'm looking at is from 2009, but they have some examples of that. And I actually don't know if this has worked in cases, but they list PTSD as a reason that somebody might not have filed. And I think that would fall into that first kind of serious mental or physical disability or illness that would have affected someone's ability to think about what they suffered and just kind of wanting to avoid thinking about the past, and that might have contributed to why they didn't file. And then there's a few others listed, including ineffective of counsel. So you can check those out in the regulations. But so be aware that there are a couple of exceptions. So even if it has been a large amount of time since somebody has entered the United States, there might still be some argument that you can make. The second really common one is firm resettlement. So if a person fled to a third country and received an offer of some kind of permanent status there, so usually a permanent residence or citizenship, then that would also bar a grant of asylum in the U.S. There are a couple of exceptions for that as well. So these are if the entering that third country was a necessary consequence of leaving their country, and they stayed only the necessary amount of time to transit through the country, and they had no ties there and hadn't established any kind of life there, you might be able to get around that farmer settlement bar. And then also if the conditions of your residence were substantially restricted by the authorities in the country, then that could also be an exception. And I don't have great examples for this because I haven't had a lot of these cases, but I know that it definitely has. We've seen a lot of Haitians recently who have had status in Brazil, and so I'm not sure how these cases are panning out across the country, and maybe someone else can speak to that, but that we've definitely seen that as a potential bar for those folks. And I'm not sure if you're seeing Haitians where you are, but it seems like there are a lot more of these cases recently. So another kind of barrier to asylum is if you're in reinstatement of removal, and so that's if you have a prior deportation order and they're trying to put you to reinstate that order and remove you, similar to expedited removal. So you wouldn't get to see a judge normally unless you claim fear, and then you would go through the same process for the credible fear interview or similar process with an asylum officer. But then if you pass that reasonable fear interview, you're placed in withholding only proceedings, and then the DHS's position is that you're only eligible for withholding of removal or Convention Against Torture Protection and not asylum. There have been some creative arguments around this in other places across the country, and there's been some success, but no, published cases. I think that the successes were mostly in litigation and kind of settled outside of the judge. But that's also something potentially to argue, or at least to throw in there in your briefs to get leverage, because I think that there is a good faith argument there that anyone's eligible for asylum, and there shouldn't be a bar regardless of what type of proceeding you're in, and that might at least give you leverage for bargaining with the DHS prior to the individual hearing. They had a client that was offered withholding of removal, and we had included this argument even though he was arguably in withholding only proceedings, and DHS offered him withholding without even proceeding to the individual, I think because they were a little bit worried about that going up on appeal. So just something to think about. There are also other bars for if you were a persecutor of others. So this comes up sometimes in Central American cases where people were in the military and forced to go after people potentially based on their ethnicity or family group. And so that's one thing to look out for. Conviction of a particularly serious crime. So for asylum, just having an aggravated felony conviction, no matter what the sentence, can be considered a bar. And also if you've been convicted of a serious non-political crime outside the U.S., These don't come up too often in my experience, but we have seen a few. One person was, DHS was arguing serious non-political crime when the person was arrested for stealing cows in their country. And so just another thing to kind of make sure you ask people if they've ever been convicted of a crime in their country as well as in the U.S. And there's some others as well. We don't see those as much, but previous denial of asylum is a bar. Safe third country. So if somebody goes to Canada first, there's a treaty between the U.S. and Canada that says that they actually have to apply for asylum in Canada and they can't come apply here, and vice versa. And then there are security and terrorism bars as well. And so those are not usually brought up for folks from Central America and Mexico. It's usually more from other countries that the U.S. kind of historically targets for terrorism. A lot of folks from Pakistan that, or Bangladesh that were part of an opposition party that was against the government were marked off as barred by the terrorism bar. And so I think some judges were not on board with that, but it's something that DHS will at least raise. Let me see. Can we go to the next slide? I don't appear to have control of the PowerPoint.
There we go.
Thanks. So if you are, or the client is barred from asylum, there's still two other types of protection that you should consider. So withholding of removal is the first one, and it's very similar to asylum in that you have to have persecution on because of one of the 5 specified grounds. So in that way, the analysis is the same. And so the standard is that it's more likely than not that they would be subject to persecution on account of one of the 5 grounds. So the definition of persecution is the same. The nexus requirement is the same. Government involvement, that the government is either unable or unwilling to protect you, is the same. There's also, for both asylum and withholding, there's a presumption of future harm if you suffered past harm. But similarly, for like with asylum, this can be rebutted by the government if there are changed country conditions or fundamental changed country conditions, or the person can safely relocate internally. And they share a lot of the same bars as well. So the persecutor bar, the serious non-political crime bar, security and terrorism bars, and also a particularly serious crime bar, although it's a slightly different standard. This is written down later on under CAT, but the standard for withholding of removal, there's an automatic particularly serious crime if you've been convicted of what's called an aggravated felony, and you were sentenced to an aggregate sentence of 5 years or more. And so that would give you an automatic particularly serious crime bar, but you can also, the judge could also find that any crime is a particularly serious crime using factors that were set out by the Board of Immigration Appeals, and I'll talk about that a little bit more in a minute.
Sarah, I think we actually have a question here in San Antonio.
Okay.
Hi, I'm Jenna. I'm also one of the Raices attorneys. I just had a question about what it means in practice that asylum is discretionary, but withholding and Convention Against Torture are not discretionary, that they're mandatory. Like, how does that play out in terms of any logistical differences or argument differences?
Sure. So, it basically means that as long as you meet the standard of harm, it doesn't matter whether the judge thinks you're a good person or that you deserve to live in the U.S., or, if you have some convictions, but they're not bars, the judge can't consider those in deciding to grant withholding or CAT. But for asylum, once you get into discretion, the judge can consider anything and really, deny for any reason, even if you've met the harm standard. But for withholding and CAT, as soon as you've proven that it's more likely than not that you'd be subject to persecution, and meet all those requirements, and you're not barred, there's no, the judge can't deny
I can
Does
give
that help?
I can give an example. I had a case that I worked on with Aiken Gump, and the gentleman was denied asylum on discretion. So he was granted withholding of removal, and the denial basis was the fact that about 10 years previously, when he was a kid, he had applied for and won the visa lottery to come to the U.S. And in order to qualify for that visa, he needed to have graduated from high school, and he hadn't graduated. So he forged a graduation certificate, and immigration figured it out and denied his visa, and this was on his record. And so the immigration judge, years later, when he's now having political problems in his home country, flees the U.S., says, yes, you qualify, you meet all of the other requirements, there's no bars, still felt like he didn't want to give him asylum. So he denied, and Aiken Gump took the appeal and won the appeal. So we were very pleased with that. And I think, practically speaking, there was a concrete issue there. But I don't think a judge is ever going to deny on discretion without articulating some reason, because then they're going to be appealed, or they should be appealed if they don't articulate a decent reason.
Thank you.
Thanks, Sarah. So that's one of the main differences between withholding and asylum, so that it's mandatory. There's also no one-year filing deadline for withholding, and firm resettlement is not a bar. You can also, like I was mentioning before, you can apply for withholding if you're in reinstatement of removal, and without DHS opposing you. And there's also another difference is that it is a higher burden. So for asylum, you only have to show that there's at least a 10% chance that you would be subject to persecution in the future. But for withholding, you have to show that it's more likely than not that you would be subject to persecution. And so the courts have interpreted that to be at least 51%, so above 50% probability. So they look at the totality of circumstances, but it's kind of a little weird calculus. It's also, unlike asylum, it's only a temporary protection. So you technically would still have an order of removal, and the judge is just ordering that you should not be removed. But you're only eligible for a work permit, and there's no path to citizenship or legal status for yourself or your family. There's also no derivatives for withholding or removal, unlike asylum. You can't travel outside the U.S., otherwise you lose your ability to come back. And you can also still be removed to a third country. And there's also, because there's a particularly serious crime bar, if you are granted withholding and then later are convicted of a particularly serious crime or an arguable particularly serious crime, you can be placed back into removal proceedings to try to, and DHS will be trying to take away your withholding. If you are placed back in proceedings, you can still apply for CAT. Well, first argue that it's not a particularly serious crime, but also apply for Convention Against Torture protection based on the same fear, and potentially be granted. Next slide, please. So for CAT, so the Convention Against Torture and Other Forms of Cruel, Inhuman, or Degrading Treatment or Punishment, it's actually a treaty that we're signatories to, and so it's not a statutory protection. But there's, unlike withholding and asylum, there's no nexus requirement, which is good for people who can't prove a nexus, but they are facing potentially death or torture in their countries. And so, especially for gang cases, it seems like there's a lot more. It's tougher to find a nexus, but there's often very serious harm that they're facing. So as you can see, the definition of torture is up there. I'm not going to read it to you, but the key is that it has to be specifically intended to inflict harm. It can't just be kind of an accidental torture. And sometimes credible threats of severe physical pain or death can constitute torture as a form of mental pain or suffering. And in addition to having to prove kind of like the harm piece, that's like the persecution for asylum and withholding, you also need government action. And so the standard for the government involvement for CAT is different from withholding and asylum, as the chart that Sarah gave out shows. So you have to show that there was either the torture would be either by a public official acting in their official capacity, or at the instigation of a public official, or with their consent or acquiescence. And that's been interpreted as meaning that they're willfully blind to the torture by private individuals. So it has to either be directly by the government or by a private actor, but that the government is consenting to their acts. And so, the examples here are, if there are police officers on duty, then that's very clearly torture by a public official acting in their official capacity. Or if they send someone else to torture someone, then that could be considered at the instigation of a public official. And an example of acquiescence could be if prison guards are allowing, they know that gang members are making threatening calls from inside prison, but they're allowing it. And especially if they know that these gang members have ties to the outside, that, to people who could actually carry out the torture in real time. And so you should be looking at both acts by the government officials and also omissions. So, depending on the circuit, it may not count if the police are like rogue police or bad apples. So they're off duty. They just decide that they're going to go after people either for kind of personal reasons or because they want to rob them, whatever it may be. Some courts have said that, or many courts have said that that's not enough because they're just rogue officers, and the government as a whole is not acquiescing because they have policies in place that are trying to combat corruption of police. And so even though they're not very effective at combating corruption, they're still trying, and so they're not acquiescing to this torture. But you should keep an eye out for what the duty of the supervisors was to know about their officers' actions, to train them, to investigate any issues, etc. And here on the 9th, we had a case come out yesterday. I think, I understand the Ninth Circuit is often far on the liberal side of interpreting the law, but I think that it maybe would give potential arguments to be making because the law can change. But the court basically said it doesn't matter what the government policy is as a whole, or if they're trying to fight torture and corruption. If there are police officers that are torturing someone, even if they're off duty, even if they're bad apples, that doesn't matter. The statute says, or the law says, if it's by a public official, then that constitutes torture by a public official, or with the acquiescence of. So in this case, actually, there was also a police officer that had declined to take their report after he learned that his colleagues were the ones that tortured the person. And so it was kind of a combination of by public officials and with the acquiescence of one public official. But the court said that was sufficient. And I think it did help in that case if the facts were really bad. So it sounds like the judge probably wanted to help this person, but the BIA had denied the case, saying that wasn't sufficient. So just something to look out for and arguments to make because there are a lot of examples of that at a local level, especially where police officers in Mexico and Central America are involved involved in kidnapping and torturing people, either because they're afraid of refusing the cartels or because they're being bribed. Whatever it is, it shouldn't matter that the governments are against that, or, that the federal government or the president is against it. If at a local level there are officers engaged in torture, that should be sufficient. Okay, next.
Just give me a minute, it's not flipping over to the next slide. Okay.
Okay. So this is the last one before Hypos. So there are actually two types of protection under the Convention Against Torture. There's, confusingly, there's withholding of removal under the Convention Against Torture. And for that, there's the same particularly serious crime bar that there is for the other type of withholding under the INA. And like I was describing, there's per se particularly serious crimes that are kind of automatic. Particularly serious crimes if the person has one or more aggravated felony convictions where they were sentenced to a combined or aggregate term of imprisonment of at least 5 years. And then there's this Board of Immigration Appeals case, matter of Frantescu, that lays out factors that the court should use to assess whether the court may presume the person is a danger to the community based on the severity of their conviction. So they'll look at what kind of conviction it was, how long the sentence was, kind of the circumstances of the case. So unlike a lot of analysis of crimes for immigration purposes, is a very fact-based analysis for particularly serious crime, and so the judge can look at the police reports, they can ask the respondent questions on the stand about what happened. So it's very fact-based, and the categorical approach is not used. So it's very broad, and there's cases that say that if the aggravated felony contains a drug trafficking element, and that they usually can presume that it's a per se particularly serious crime. So it's very broad, but it's definitely something that should be argued, that the person's crime is not doesn't fit within that. The second type of protection under CAT is deferral of removal, and there are no bars. And so as long as you meet the other standards for the level of torture and the government involvement, then it's mandatory, and there are no bars to it. In practice, really the only difference is the work permit, but you still get a work permit for each. We have to pay for one, not the other. And yeah, so that's pretty much that. So again, CAT is often used if people are either barred from asylum or withholding, or there's no nexus. Kind of the main reasons for CAT, because it is a more limited protection. Like withholding, there's no path to citizenship, and all those other kind of limitations of withholding are the same. Can't travel. So that's CAT, and I don't know if you want to take questions first, or you want to go through Hypos first.
Let me see if I can launch this poll, and
Okay.
Bear with us, everyone, for just a moment. We're working on learning the system here. Okay, so the poll should be open now. If those who are on the webinar wouldn't mind entering their response, I'll just give it a couple of seconds. For those who are here in person, the poll is basically for us to gauge what level of experience the attendees have.
Do you want us to answer in person?
How many here have done work on an affirmative asylum case? On a defensive asylum case? Okay, so we've got a couple people.
Can I ask just a clarifying question while we're doing the poll? The difference between when you would want the CAT withholding and the CAT deferral would just be the level of the serious crime conviction that you might have in your past. Or like, why would you ask for one and not the other if you can get a work permit with one and not the other?
Sarah?
I'm not sure if I completely heard it, but just asking what's the difference between withholding and deferral under CAT?
I think
Or
you'd
like
always
why
try
would you
to
ask
get
for one, not the other?
withholding under CAT, right?
Just if you were barred.
Yeah.
Okay.
Okay, so I'm going to close the poll. And it looks like a good group has some training and volunteer experience, a couple people with some litigation experience on the call. So a little bit of a mix. Sarah, do you see that poll on your screen?
I saw the poll, but I wasn't able to see the results.
Okay, so it looks like this is my first training, 21%. I've had some training volunteer experience, 43%. I've litigated 1 to 3 asylum cases, 14%. I've litigated 4 to 6, 14%. And I've litigated more than 7 asylum cases, 7%.
Okay. Thanks.
Okay. So I think actually before we do this first typo, does anybody have any questions on the presentation?
And a reminder to those watching remotely, you can chat us questions or shoot an email to asylumhelpsa@raicestexas.org.
I have a question. What was that application that needed to be filed within the first year?
That's the asylum application.
And that's a number?
So, good question. Let me clarify that. So, the form number is I-589. That's the application for all 3 forms of protection. So, when you file a form I-589, you're filing for asylum and withholding of removal automatically. If you also want to file for protection against torture protection, you need to mark the box for torture protection on that first page and also on page 5 of the application. Okay, so let's go ahead and go to the first hypo here. So Mr. H is a member of the Southern Cameroon's National Council, an Anglophone secessionist movement that has faced widespread persecution by the government of Cameroon and was declared an illegal organization by the president. From 2008 to 2012, Mr. H was arrested multiple times and always beaten. Once while he was in custody, police beat him and cut his leg with a machete. The police accused him of trying to separate the country and told him to stop his activities with the SCNC. Mr. H escaped and fled to South Africa, where he was given a work permit. After a recent increase in xenophobic attacks in South Africa, he decided to seek refuge in the U.S. He took a flight to Mexico, then presented himself at the U.S. border asking for asylum. So he's an arriving alien, which means he's going to be, if he passes the credible fear interview and requests release, will be released on parole and will be immediately eligible to apply for a work permit. I know we didn't really talk about work permits today. It's a little bit outside the scope, but just be aware that depending on the manner of the person's entry, they may immediately be able to get a work permit regardless of whether or not they're filing an asylum application. Okay, so what is Mr. H's relief? What can he apply for?
Torture?
CAT, yep.
It's a government official, that one section with the police.
Yep, government official action. What about asylum? Let me launch this poll here for those who are on the webinar. Okay, so launch. What do you guys think? Was there past persecution in this case? Does the harm rise to the level of persecution?
Many beatings?
Let's see shows of hands for maybe yes. Shows of hands for no. Okay, it looks like everyone's pretty much in agreement that probably rises to the level of persecution. Okay. Next question. Was the persecution on account of a protected ground? How many people would say yes? Account one of the protected grounds? Okay. No's. And if so, on what ground? Okay. Now we also have here a couple people. This is a little bit of a trick question for the people online because you can only, I think, pick one option. So definitely a political opinion, but you don't have to choose just one. You can claim asylum on all 5 grounds if you want to. So there's a couple people here who seem to be changing their responses. But we have a couple people going in for nationality and a couple people going in for social group. Okay. So I'm guessing for social group, and if anyone wants to comment, you can feel free to put that in the chat box. For social group, perhaps the fact that he's part of an Anglophone secessionist movement, so not just a member of a political party. And that might be tied to, say, a particular region of the country, which, Sarah, I know you prepped this hypo, so you might have a little bit more background, but I understand that the Anglophone region is part of northern Cameroon. Is that correct?
It's kind of in the west. It's like a little.
West? Okay.
It's definitely a region that looks separate. It's kind of a little chunk on the side.
Yeah. So there's things like language and other differences that might make it possible to form a social group. And then there's a couple people here, Sarah, who are also putting down nationality, which I think if we're doing nationality, we would probably also mark race. So ethnic groups can often fall under social group, nationality, and race. And I'm not sure if there is a different ethnicity here that might be involved, or if you think race or nationality would come into play.
I'm actually not sure about that. I think that it's a mixture of different ethnic groups that are part of the English-speaking region, but I'm not sure about that. It would be something to research.
Yeah. So, I mean, you guys are asking the right questions, right? These are the things that you want to talk to your clients about and then do country conditions research to corroborate. And I think we have one more question here for the poll. And that is, let's see, show of hands. Can he get protection in Cameroon? Yes? No? Okay. Let's see, people here are saying no. Yeah, probably not, right? So I think I skipped over this part, but it is good to keep in mind that if the persecutor is the government, our laws assume that that person cannot get protection anywhere in the country because, in theory, the government's in control of the country. So even if it's a local police station, because it's our government officers, there is a presumption that internal relocation would not be reasonable. And definitely keep that in mind. That's an argument you'd want to make. Now, are there any potential issues that would prevent relief in this case? Yes?
The work permit in South Africa or resettlement issue.
Yeah. So do you think that's going to be, it's definitely an issue. Would you say yes or no that's going to bar the guy? I mean, I know we don't have a lot of facts in this case. So it might be hard to decide.
I think you can make the argument that it wasn't permanent residence. It was just authorization to work while he was there. And you would argue that it was more temporary than not.
Mm-hmm.
But there's nothing about if he ever tried to seek protection in South Africa, like if he could have stayed there longer, if he would, if he was actually in danger. It doesn't say that he was ever attacked, just there was an increase in xenophobic attacks, right?
Yeah, I looked at this issue actually for South Africa specifically and spoke to the UNHCR there about their point of view and won a case on this issue, but this was several years ago, so take this all with a grain of salt. Do your own research, please. But South Africa will accept people and give them temporary refugee permits, which are usually good for about 3 months. And then they can apply for, and that's sort of the first step in applying for refugee status. From refugee status, they could, similar to here, they can apply for permanent residency. Because of the conditions, the limitations on that actual status, the UNHCR doesn't consider that to be firm resettlement. So even once you get past the visa stage and you actually have refugee status, which I think there's a limit on that. I think it's good for something like 5 or 6 years, and then you were supposed to apply for permanent residency in that process. And because permanent residency is not something that you get automatically. So it's not just you fill out a form and apply, but there's a lot of hurdles to actually getting it. It's not considered to, even having that refugee status, enough to show that you have a clear pathway or clear option for getting permanent residency. If someone does have that option, however, and then they just decide they don't want to go through that process, they want to come to the U.S., you can look at it as forum shopping. You can't do that. So even if a person doesn't have permanent status, you have to see if they have a pathway to that permanent status, because that'll prevent them from getting asylum under the firm resettlement bar. Sarah, I think, were there a couple other things we wanted to mention about this hypo?
No, I think we touched on everything, and I purposely made it vague about the work permit, because people often don't know exactly what status they had, and they'll often tell you, like, well, I had a work permit, or I had, like, some kind of refugee document that it couldn't work, or, so it's often that you need more information from the client.
Practically speaking, try to get a copy of it. And they might have conveniently lost it when they were traveling through Central America. But you can also look up online sample copies, and show them to your client and say, hey, does this look like what you had? And just be very clear with them that you need to know, because you're going to have a really hard time presenting an argument to the judge if you don't know exactly what they had. And the trial attorney might find that information regardless. So the case where I mentioned that was denied on discretion, one of the reasons why the BIA remanded it and he was able to get asylum is because he was honest from the get-go. From the time he came to the border and talked to Customs and Border Patrol to the whole conversation he had in court. And I can't emphasize enough the value of really spending time with your clients to make sure that they are honest with you and feel comfortable enough to be honest with the judge. So hypo 2, hold on. Sarah, do you want to do this one?
Yeah, it looks like we only have 2 minutes. Is that?
Yeah,
How do you want to proceed?
Well, let's just do one more hypo, and for those of us who need to step out at 1 o'clock, that's fine. Just so everyone knows that the PowerPoint should have been shared with you, and if it hasn't been shared, we'll share it with you subsequently so you can read through those. But yeah, let's just go through one more for those who do want to stay around a couple more minutes.
Okay, sure. So Miss G is a 23-year-old woman from Mexico. During her childhood, her father would beat her and her mother with cables and belts. He would also lock her inside the house and make her do housework. So her, Miss G. When she was 16, she left her father's house and moved in with a boyfriend who turned out to be a member of the Sinaloa cartel. After a while, he became physically and verbally abusive, telling her that she'd be sorry if she left him. And she was able to escape her boyfriend in June 2014 and fled straight to the U.S. She was paroled at the border and given an MTA, and so she was released. And her first master hearing was set for December 2015, and she appeared without a lawyer per se and asked for a continuance and had a couple more court dates in between maybe, but never filed anything. And she's now seeking counsel for her next master hearing in March 2017. So did you have a poll for this?
Yeah, I can go ahead and just launch that. So the first poll is the persecution on account of one of the protected grounds, and if there are several, just pick the one that you think would be the most applicable in this case. So let me launch that.
Mm-hmm.
From the audience that's here in San Antonio, what do you all think? Race, nationality, political opinion, religion, particular social group? Any of those viable for her?
Social group.
Maybe particular social group? We have about 50% of the people online who have voted, and it looks like we're coming in at 100% for particular social group.
Okay, good.
And what can someone say what that particular social group would be? Domestic violence. Okay. How is what is she a group of?
Women escaping domestic violence.
Okay. How is that immutable?
That's the thing. I don't think there's like a very clear particular social group. So this might
This
be
is going to be a good
situation.
segue to.
It is a good segue
One or two.
for this afternoon.
I think you have to be creative.
Yeah. Yeah, and so Andrea has, we'll talk about the case law on that this afternoon, and there are some cases that don't fit into the case law as well, so we'll talk about strategies for that also. And let me go ahead and launch the next poll. Okay. Next one, can she get around the 1-year filing deadline bar? Show of hands, how many people think she can get out of the 1-year filing deadline bar? She missed it, right? She went to court, but she didn't file anything yet with the judge. Yes, she can get out of it, maybe? Okay, no? How many people for no? Okay. So it looks like we're for those online, we have 40% saying yes. Now someone's changed their mind. Let's see. Or actually, I guess more people have voted. So, no. Hold on. Let me just give it a minute. It's still fluctuating a little bit. Okay. We have about 50% yes and 50% no exactly online. And here I think we were a little bit more in favor of no, but also a split.
Mm-hmm. Yeah, I think that was kind of my assessment. I think it would be pretty difficult unless there was something that she hadn't told us, like maybe she consulted with an attorney and they promised to file the application on time, but then they failed to do so. So ineffective assistance of counsel is one of the exceptional or extraordinary circumstances that's contemplated in the regulations. But you would need more information to find that out. You would also want to ask her, why she didn't file. But it does seem like if she had it together enough to go to court, then probably any argument related to, the mental or legal or physical disability probably wouldn't work. So I think it would be difficult.
Yeah. One thing to keep in mind is the regulations. In fact, I'm not even sure it's the regulations, Sarah. Maybe you know if it was just a EOIR policy change, which I believe it might have been. So there used to be a process for lodging an application with the court before you actually had a hearing. Now you can actually file at the court window. So she might have made some efforts, and maybe she did in fact lodge, but she didn't do motion to advance. So there's some, because of the time here, you'd want to really look into everything that she did, including procedurally. The other thing is, I think, so you'd mentioned this earlier, she needs to, as soon as she finds out that she missed the deadline, take as much expeditious action to get her application filed as possible. So if she finds out, today, because she came into your office, and her hearing's not until March 2017, I would be filling out that application now and submitting it to the court now and not waiting 2 months. And you might have to do a skeleton one. If that's what you need to do, that's what you need to do. But you want to, once she has knowledge of the deadline, she definitely needs to take action. Yeah, question here.
Would it matter that her first master calendar hearing was after that 1-year deadline?
No.
Okay.
No. And we see that all the time, unfortunately.
That's why we're...
Even for pro se.
Yeah.
Yeah, and so Sarah's...
We're currently challenging that, too.
Yeah, Sarah's organization, Northwest Immigrants' Rights Project, they have litigation saying that there should be a notice requirement of that 1-year filing deadline. Now, Customs and Border Patrol, so if someone is in removal proceedings, they do give them a piece of paper that's written in English saying that there's a deadline, I believe. But there isn't, I don't think, any Spanish advisal to that effect, or in Quiche or whatever other language.
Now, I'm also wondering if her case did make it to a judge, could he possibly deny that because she's in Mexico and she could have gone anywhere else prior to the U.S. first, deny her asylum here? I mean, I know it's the cartels, so that's something that's so prevalent and new, and it's, yes, people are getting killed. But could he argue, well, you could have gone to another state, your relatives within Mexico?
Right.
Mhm.
So that touches, I think, on two things. One is safe third country.
Mhm.
So if she happens to also have dual citizenship in Spain or in Guatemala, she is expected to go there. Now, the law on this isn't 100% clear. I think there is an argument that because of the language of the statute, you could say that she might have a path. But there is a BIA case decision directly on that issue. They said no, and I think it's not in the spirit of the law. So I think if you were going to try to fight it based on statutory interpretation, you would have a really uphill battle. And then the other issue is, I'm going to change your hypo just a little bit. Let's say this is someone from El Salvador, and this individual has traveled through all those countries on their way to the U.S. There is a question on the application that asks if you had legal status in any of the countries that you traveled through. Did you request asylum in any of those countries? And you should be honest. Most times, people don't have legal status, or at least nothing permanent, so there's not going to be a firm resettlement issue. And then often they're not asking for asylum. But if they did ask for asylum and the case was in process, you might have a little bit more complicated situation. Sarah, have you ever seen in any of your cases someone have an issue because they did not apply for asylum, say, in Mexico? I've never actually had that been an issue, but I could see where the judge would ask about it.
No, not that. We have seen a couple of people who actually got some kind of permanent residence in Mexico, but then suffered DV there too, and so we were able to kind of get around it. But no, we haven't had them bring up, why didn't you? I mean, the judge will ask, but then it's never been an issue.
I think the question was also touching on internal relocation because Mexico is a big country.
Yeah.
So I think that is something that you would have to address and have a good explanation. I mean, if it's because it's the cartels, if you could get country conditions evidence showing that the cartels can track people down anywhere in Mexico, then that would be really helpful. But
That was
yeah.
our next poll question.
Yeah. Okay, well, that was her.
Yeah.
Sorry, I didn't realize that. Yeah, but I think that's what her question was getting to.
More reference to internal relocation.
Yeah.
Mm-hmm.
That's a big issue, I think, for the Mexican cases. I suspect that there's such a low approval rate in part because of internal relocation. And I'm working on a case right now, and I don't know if I'll be successful or not on that point, but I think you have to focus on it being the government's burden, and they need to present their evidence. And in this particular circumstance, which we've seen a lot with the Central American families, there might be characteristics of the individual, like a single mother, age, education, that would make it really difficult and maybe unreasonable for that person to move to another city. Not because the gang is going to follow her, but because of other factors. So, none of these things are completely straightforward, and I think you guys are right in terms of just knowing to really think about these issues and ask the questions. So was there anything else about this hypo we wanted to ask or add?
No, I guess I just kind of parsed out the analysis for withholding, so she is barred by the 1-year deadline. I mean, safe relocation still might be, an issue, but I think we would maybe need more facts, but I think that DHS would definitely argue that she hadn't met the standard for future persecution by her father because she's now an adult, or they would argue changed circumstances, so the presumption doesn't apply. And then as for the boyfriend, I guess depending on, they might argue, well, he's got a new girlfriend now, he doesn't care who you are, and it's been a couple of years now, and he forgot about you. So I feel like they would, maybe ask those questions on cross and try to get at that he has no interest in her, and so then her likelihood of future persecution doesn't rise to the level of 51%. But.
Yeah. And, you can always challenge the law, too. Just, keep in mind that if the circuits are all in agreement about the 1-year filing deadline, you could still challenge it up to the Supreme Court. There are people who have looked at that. There are people who have looked at the issue of someone who's in in reinstatement and removal, still being eligible for asylum. So, you know, we have the law as it stands, as it's been interpreted, but that doesn't mean you can't be creative with your litigation strategies. Is there anything else for the audience?
No, nothing from me.
Questions from anyone before we wrap up? Okay. Thank you all. We're going to disconnect.
Thanks, everyone.
Okay, so we've got about little 15-ish minutes for a break before we get started. So feel free to get some more food, go to the restroom, stretch, ask questions. Kind of complicated. Maybe ask.
have any questions, there is a chat box. Also email asylumhelpsa@raicestexas.org. We'll be checking that email on and off throughout the presentation. So if you have any technical difficulties, please let us know, or any questions about the subject matter that we'll be covering today. So I'm going to go ahead and turn over the presentation to our first speaker, Andrea Mesa, one of my colleagues here at Raices, to discuss gender-based asylum claims.
Hi everyone, thanks. And just for those of you who might have joined in online for this session, we just finished up a session on the basics of various forms of protection. And so those of us here in San Antonio, most of us listened to that presentation. And now we're moving on to diving into a little bit more deeply some of these issues. So we can go on to the first slide. So just a reminder as to where we are when we're talking about domestic violence and asylum. This falls into the particular social group grounds for asylum. So just, this slide is a lot of information, but just a reminder of what we're talking about. Since then, that the BIA had found a PSG based on this gender idea of gender plus. So gender is something that you can't change. That means it's immutable. So if you add on characteristics, that could constitute a PSG. And then they also said that marital status can be an immutable characteristic when the woman is unable to leave the relationship. They said that the PSG was socially distinct because DHS conceded that it was, and also because there is unrebutted evidence that there was a culture of machismo and family violence in Guatemala. And they noted that there are laws in place to prosecute domestic violence, but there's very little enforcement. So that sort of showed them that the category of women who can't leave a relationship it has meaning in Guatemalan society because, and some of that evidence was the laws that were on the books. And then the group was particular because the terms used to describe the group, married, women, and unable to leave the relationship, have common definitions in Guatemalan society. And they said that, and going back to marital status, things to look towards are cultural, religious, moral, and legal constraints that shows that you cannot leave, so that makes marital status immutable. And I think we covered the rest, so let's move on to the next slide. So some evolving issues that were sort of left open or open for development are what that marital status is, if you're actually unable to leave, potentially gender, and whether or not the government's unable or unwilling to control your persecutor, and then proving nexus. So again, there's a lot of info on here, but I like to put it there for you to reference later. I'm not going to read every word on here. But it turns out that in the unpublished decisions since ARCG, marriage is not required. And so in looking at these cases and going through the sort of open questions that I mentioned, we're talking about unpublished BIA decisions. So that means it's not binding precedent. It can only be persuasive in the sense that you're sort of showing the judge that, look, this is the way that the BIA has ruled in a case with similar facts. So if you do the same thing, you're not jumping out on a limb here by deciding this way. But of course, it's not binding, so the judge doesn't have to follow that guidance. And so I got some of these cases from an article I think I cite in one of the slides, from a brief that some of my colleagues wrote, and then just from sort of being in touch with listservs, people sending out other positive BIA decisions that have come down in the last 2 years. So as far as cases where the fact showed that the woman was never married to her persecutor, one of the first unpublished decisions after ARCG in February of 2015 said that the absence of a legal marriage is not ipso facto a distinguishing factor. So you don't have to be married. But in this case, all of these cases are very fact-dependent. So you have to look at sort of what facts led the BIA to decide that. In this case, the woman had been with her partner for 19 years, they had 3 kids, and the police told them to resolve their problems themselves. So even though they weren't legally married, they definitely had a relationship that the BIA saw as being analogous to a marriage. And then in June of 2015, they sort of clarified that the particular terms are women, domestic relationship, and unable to leave. So that's a departure from ARCG, and that they are now saying domestic relationship instead of married Guatemalan women. Here the facts were that the family, the partners lived together for 15 years, they had 5 kids. Although the woman never called the police herself, neighbors did, and she was actually in Mexico, but she kept going back to El Salvador because her children were still there. And then in another case, the couple had cohabitated for several years, and the police told the woman that they needed to resolve the problems because they were bound together through a common child. So in that case, again, the child sort of showed the BIA that there was a relationship that was analogous to a marriage. In 2016, there was a case where the BIA said that divorce didn't mean that there was a relationship that she was unable to leave. And then in another case in March of last year, they didn't require that there was a time link to the relationship. It was a relatively short relationship, not like the 16, 19-year relationships we had seen in previous cases. But in that case, again, there was a child together. So on to the unable to leave prong. Turns out it's actually okay if she left. There had been a couple cases where the couple was living apart, and referencing that same one from 2015, the woman was actually in another country. But again, the children were what tied them together and were what showed that she wasn't able to leave the relationship because she still had a connection to the persecutor based on the shared children. And then another one where she was living apart from her abuser, but the presence continued. So in that case, she had moved out of the home, but the abuser, frequently went by the house, and even though she had separated herself from him, he did not view that separation as actual separation and was constantly harassing her in her home. In November of 2016, the BIA pointed to facts that showed that the woman wasn't able to live a normal social life. So she had moved out, was living separately, but the persecutor kept coming by and harassing her in public. And when he saw her with another man, he beat up the other man, and I believe beat her up too. So in that case, the BIA focused on the fact that she wasn't able to live a normal life, and because of that, they decided that it was sufficient to show she wasn't able to leave the relationship. And I would recommend looking at an excellent brief written by the National Immigrant Women's Advocacy Project and the University of Texas and St. Mary's Law Clinics to the Fifth Circuit. They outline some of these considerations, especially that an abuser in a patriarchal country with an emphasis on family won't see physical separation as actually leaving the relationship. There is lots of evidence in the context of domestic violence that leaving is actually the most dangerous part of an abusive relationship. That's when the abuser feels like they're losing control and may lash out even more. If there's children in common, they will likely have some sort of continued relationship through those children. And that when you leave, an abuser often targets a third person, such as children or family members of the other partner, for violence. So we can move on. Let's see. Okay. It looks like some people might be having trouble with viewing the slides. I apologize for that. We have these sent out in, or sort of broken up into several short presentations. So as soon as we finish up with mine, I'll send out these slides and make sure everyone has the slides for the subsequent sections of this presentation. Okay, so gender. I would say that it's arguable that you can say that it doesn't have to be a female victim and a male persecutor. And this comes from a decision and again unpublished from June of 2015. Nothing in the facts suggested that there was not a heterosexual male-female relationship, but the language of the decision said that ARCG does not, quote, necessarily require that the applicant have been, quote, married to his or her abuser. And then again, they said, which is a common line, that rather you look to the characteristics of the relationship. So in this case, they said his or her, so I think that an argument could be made that at least the victim could be male or female. But then they did say that the particular terms were still women, domestic relationship, and unable to leave. So that sort of falls back against the idea that maybe it is his or her when they're saying that at least in this particular social group, one of the key words was women. But I think you can still lean on their previous words. But even delineating those terms, women, domestic relationship, unable to leave, leaves open the question of the gender of the abuser. So we recently argued at Raices a case where the persecutor was a woman and the victim was a woman. Unfortunately, the IJ did not agree with us for many reasons, but we are appealing that decision. And these are tricky because part of the BIA's PSG analysis in ARCG relied on this idea of machismo, especially for the social distinction prong, saying that women who cannot leave relationships is a socially distinct group because of the idea that in some of these cultures, that men view women as property, that they control them, that women are subservient. So because of that, it might be tricky to argue that a victim could be a male, but I don't think it's impossible. So moving on to the next slide. There we go. So the government unable and willing to control. So this is going to be an issue in all of your asylum cases. But here, the question is going to be, how much evidence do you need? And then a couple of the cases since ARCG, In one of them, the woman actually did have restraining orders, but the BIA said that the government was unable and willing to control because they were not actually enforced. So sometimes we've seen this come up in cases where the woman did go to the police and they did try to do something, but it wasn't effective. So there's at least this persuasive decision that might say that that is not preclusive of a finding that the government was unable or unwilling to control. And then in another case from March of 2016, the woman filed police reports, even though she didn't do sort of a final report that the police had requested. And the BIA actually said that the judge didn't fully consider the background information for unable and unwilling to protect. In this case, the IJ relied on the existence of laws and programs for domestic violence, so sort of citing to the fact that there were efforts to curb domestic violence and using that to say that the government was willing to control the persecutor. But in this case, the BIA cited the country conditions evidence showing that domestic violence is a widespread problem and that women are reluctant to bring a complaint. So this kind of shows the importance of country conditions evidence and really looking for good reports for your case. So do you have to go to the police? A couple of reminders. You should not have to show that the government was unable or unwilling in your particular case if it's demonstrated that reporting to the authorities would have been futile or created the risk of further abuse. That's from Matter of SA. And also, laws criminalizing persecution don't necessarily prove willingness or ability to protect. That's from Matter of OZ and IZ and also from UNHCR guidance. One little caveat, in all the cases that I was able to review for this, there was some element of someone going to the police though. So I think you can still argue that even if no one ever informed the police of this, based on those little reminders, that shouldn't preclude a finding that the government was unable or unwilling to control. But just to note that in these cases, at the very least, the neighbors called the police, even if the woman had not done so herself. So then on to the next slide. Oh. Okay. So arguing nexus. So how do you argue that one central reason the abuser abused your client is that she is a woman who is unable to leave her relationship? Well, there's a couple of examples. Actually, in a lot of the BIA cases since ARCG, they didn't really focus on nexus that much. Go figure. It was just sort of assumed once they got to the facts that I guess they thought were sufficient to meet that threshold, then they said that that she was persecuted on account of that particular social group. And in one case in particular from December 2016, just last month, the IJ said that there was no nexus, but then the BIA in their text said, however, the record indicates that the ex-husband abused her from his position of perceived authority as her ex-husband and the father of her children, and threatening comments from her brother-in-law, who in this case was actually a police officer, and said things to the effect of, you'll never be able to leave him, you have children with him. So basically that confirmed that it was one central reason for the persecution. And then some of my colleagues at Raices filed a brief in a case that went to the Fifth Circuit. And in that case, there were facts that the woman testified that her abuser said that she was never going to leave the relationship. And there was testimony that he said things saying like, you are my woman, and facts such as you can't be with anybody else. And so in this brief, my colleagues argued that the threats and violence to enforce power and control over the petitioner because of her status as a Honduran woman unable to leave, and his express basis for the abuse was tied to the belief that she was unable to leave the relationship. And so basically what they meant by that was that her inability to escape sort of told him that he could do whatever he wanted to her, that she belonged to him because he knew that she couldn't go anywhere. So those are just sort of some examples of arguments you can try to make when you're trying to show nexus in these cases. And I think what's really important here is getting the specific testimony about what words were used. Sometimes can be really crucial, so it can be really important to ask the woman, not just what happened in terms of the persecution, but trying to get to the crux here, the nexus of why this happened and why he was doing it to her, trying to get testimony and evidence that he told her, you can't be with anybody else, you're going to be mine forever, that you're mine, anything that sort of shows that he believed he had control over her. And so then we can move on to the next slide. A few circuit cases have been decided since the ARCG. And one from the Fourth Circuit, these are all from last year. And actually none of them succeeded. So this is a sort of example of what might not work. The PSG was Salvadoran women in intimate relationships with partners who view them as property. I don't think the issue in this case was so much the particular social group, but in this case, the couple never lived together. The abuser was in jail for 12 out of the 18 months. She asked him for financial assistance while he was incarcerated and lived in a house that he paid for, and she never went to the police about the abuse. So the BIA held that that it was not an immutable characteristic. There was no evidence that she was unable to leave. The group was not socially distinct. There was no nexus, and there was no evidence that the government couldn't protect her. So again, I think the facts in this case just weren't the strongest. And then one from the Second Circuit. This was an unpublished decision. The PSG was minors abused by custodial family members and young women vulnerable to abuse. And in this case, the grandmother was the one abusing a young woman, and the court held that it was not, the social group was not particular. So I think that it's possible to expand ARCG to include family violence. So I don't think in this case that the facts were necessarily the problem. I guess I should clarify, the simple fact of grandmother abusing the granddaughter. I think that it's possible to make an argument that she was unable to leave a family relationship, and if you could get facts that showed that, I think it could work. I think in this case, the particular facts just didn't really reach the level of persecution or showing that she was unable to leave, just based on what they explained in the decision. And I also do think that the PSGs, because there weren't great facts, weren't the strongest. But I think if you do base particular social groups for family violence, say by abuse by a parent or even by a sibling, on gender plus, so going back to the woman unable to leave and then defining the relationship, I think it could be possible. And then another case from the Sixth Circuit, the court found that the PSG was particular, but in this case they denied because there were a lot of credibility issues. Reading the case, it was a little unfortunate because at first, it sounds like in the first filing of the 589, the asylum application, that maybe they didn't get a lot of detail from the woman. There was just evidence of sort of some marital problems, and that was about it. But then in a subsequent filing, an amended 589, they got into a lot more detail about how he was actually part of a rival political group, and that's another reason why he was persecuting her. So I think, unfortunately, it just sort of reading the decision, it sort of sounds like it could just be an issue of the client really not coming forth with all the details at first in a timely manner, which is unfortunately an issue when you're working with people who have been traumatized, and also sometimes time constraints. Maybe she found an attorney right before the one-year filing deadline, so that's why the first application didn't have full details. Because it didn't seem like the stories were incongruent, it was just a lot more, and so because of that, the court found that she was not credible. So going on to the last slide. Next one. So other potential PSGs. In one unpublished case from November of last year, two PSGs that were not addressed by the judge, and so on remand, the board told the judge to address them, was Salvadoran women viewed as property by virtue of their status in a domestic relationship. So looking at it through a lens of viewed as property, not so much unable to leave, which again is one of the PSGs that DHS put forward in the brief for a matter of LR. And then Salvadoran women unable to leave a domestic relationship with a close gang affiliate. And then another one is in a case from March 2016, the respondent proposed women who are victims of domestic violence in a relationship she cannot leave. But in that case, the BIA said that it was not cognizable. So small quiz. Does anyone see issues with any of these PSGs? Again, thinking about the gender plus. So far we've sort of narrowed it down to women, unable to leave, and relationships. So sort of thinking about the PSGs in terms of those building blocks. Does anyone have any ideas of what some potential issues might be in these? Let's start with the last one. Women who are victims of domestic violence in a relationship she cannot leave. So that one, we know that it didn't work. And why did it not work? Well, I think it's the clause of victims of domestic violence. So you can't have the PSG can't be based on the persecution. Like the persecution can't define the particular social group. So you can't be persecuted on account of your persecution, more or less. So I think the fact that they threw in who are victims of domestic violence is sort of what killed that PSG. And I'm assuming that there might have been issues on the facts. Actually, I think in this case they did remand it, but they said that this proposed PSG, because the attorneys put forth several, was not cognizable because they had defined the group based on the persecution. And in the first couple of examples, the viewed as property. So that's sort of, again, the second one that DHS put forth in matter of LR, but that one really hasn't stuck yet. Most of these have been the woman unable to leave relationship. And so, in my opinion at least, I think it's a little bit harder to show that the man viewed her as property. I think that some of those questions that we talked about, asking your client where you're saying, what did he tell you specifically, and if he said you're mine, you can't leave, those might go to that, but I think that the board has felt more comfortable taking those facts and using it to bolster the unable to leave prong. So just from looking at these decisions, it didn't look like the board was really keen on the viewed as property PSG. And with the second one, women unable to leave, domestic relationship, so those are those three sort of building blocks we talked about, but then they tacked on here with a close gang affiliate. So I think here they were just trying to make the group a little bit more particular by adding in a little bit more definition there. And in this case, the board did remand it, so they were successful on account of just the women unable to leave domestic relationship. But again, this was just another PSG that they put forth in case the judge didn't agree with their first one, and they wanted to narrow it down a little bit by adding that with a close gang affiliate. But I think it's kind of tricky to define who is a close gang affiliate and that he persecuted her because she was unable to leave a relationship with a close gang affiliate. So I think, again, I understand why they added that on to sort of narrow it a little bit more and hopefully, and hoping that the judge might buy that one, but I think they ended up being successful on the more general women unable to leave relationship. So are there any questions right now? I know we kind of sped through.
This isn't really a question, but it's just a comment. I mean, for people who have physically left, even though the abuser views that they haven't left, another idea might be arguing like former girlfriend of, like an MS member of a gang member. Like there might be another way to phrase it that doesn't rely on the ARCG language.
Mm-hmm. I think that I don't think that you shouldn't put those forth because you should always put forth anything that you think is viable and hoping that the law might change. I mean, that's how ARCG came about. But I just think that from the decisions, again, although unpublished, it looks like the board is really sticking with the women unable to leave relationship and then sort of mixing those up a little bit as they might see fit. I think that the issue there with former girlfriends might be the particularity and social distinction. So is a former girlfriend viewed as significant in that society? That would be the question. And then could you determine, looking at society, and it doesn't have to be ocular visibility, but would you be able to define who is and who is not a former girlfriend?
I think there's some guidance on that too, though, right? I mean, there's from the UN, like defining highness and things like that. So one question I had, and maybe would you recommend from a practical standpoint putting forth as many PSGs on your application or to the judge as possible?
So the question was, would we recommend putting forth as many PSGs as possible? I would say maybe not as many as possible, but definitely more than one. And Sarah might have some more thoughts on this. She has more experience with asylum cases than I do. But I think that anything you feel like you have a strong argument for. So in the case where we had the woman who was abused by another woman, we put forth a lot of PSGs, but it was because there were a lot of complicating factors that sort of carved out a bunch of different potential social groups. So in that case, we did put forth quite a few, but we had really, I thought, strong facts for each one and really solid reasons for why we were putting forth each one, just because there were a lot of twists and turns in a really long fact pattern. But I don't know if I would necessarily put forth just as many as possible just to sort of go on a fishing expedition. But I think more than one is definitely recommended. What do you think, Sarah?
I think reasonable minds differ on this. I think the fear is if you put it down anything and everything that you lose credibility with the judge, and he's not really going to, or she's not going to really believe that you have solid backing for each of those arguments. So I think the question really isn't so much what number should you put, it's more, is it based on the facts of your client's case? And can you make a bona fide argument under the law? I tend to fall more on the side of the spectrum of list all your arguments in the legal brief and then focus on the most powerful ones in court. Simply looking at whether or not you might end up appealing this case, there could be a decision that comes out in the interim, and if you haven't put forward a particular PSG, you might be doing disservice to your client. But I think you have to be really careful to not just write down whatever previous legal decision said was a good PSG and really have it grounded in the facts of your case. If there aren't any other questions for the moment, we probably should switch over to our second speaker. Jeff Hoffman, who's the clinic director at the University of Houston, will be talking a little bit about how to use political opinion arguments in gang and extortion-based cases. So Jeff, can you hear okay, and are the slides up on your end?
Yes, I can hear fine. Can you hear me?
Yes, we can. Perfect.
Okay. Okay, well thank you, Sarah, for inviting me. I'm going to be talking about political opinion in gang-based asylum. I'm going to try to keep it very brief so that there's time for questions. So I think I only have 5 or 6 slides, and I'll try to move along. So I think the first thing to say is that political opinion claims are still viable in gang-related cases. Obviously, you need sufficient circumstantial and direct evidence and/or direct evidence, and you need to. Most importantly, I think what I'd like to start off with saying is that you need to overcome a very important case by Justice Scalia, called Elias Zacharias. So, Elias Zacharias was a case where the guerrillas asked the respondent and his parents to join them. They went to the house, knocked on the door. All of them refused. They said that they would think it over. The guerrillas came back a couple times, and the respondent left and came to the United States. Unfortunately, when he got to the United States, he testified at the hearing that he was afraid that the government would retaliate against him and his family if he joined the guerrillas. And he didn't really give any political opinion testimony that would be sufficient to support finding that it was his political opinion that was the motivation for the persecution or the threats of persecution. So the important thing about this case is that the judges are going to, and the officers hearing asylum claims are going to point to this case initially and say, well, under Elias Zacharias, resisting gang recruitment, and again, Elias Zacharias is not about gang, it's about the guerrillas in Guatemala, but the analogy is this is going to be an impossible claim, because merely resisting is not sufficient. So how do you get beyond that threshold? I think that the most important thing to point out is that there have been some cases that we can look to for models or templates where the respondent is able to overcome that threshold, that initial negative, obviously very important decision from the Supreme Court. So let's talk about Marroquin and Martinez-Buendia. So in Marroquin-Ochoa, the case is an Eighth Circuit case. Basically, and I reread it today or yesterday, it's not a great case, and it doesn't really come out in favor of political opinion, but it does have good language that basically says that opposition to a gang such as the MS-13 may have political dimensions. But then they say, but refusal alone to join the gang is not necessarily politically motivated. So again, they cite Elias Zacharias, and they make the point that even though the MS gang, Mara Salvatrucha, is not a garden variety gang, it is rather political in nature. The mere refusal to join the gang is not sufficient to find imputed political opinion. And then they, very interestingly, in this Eighth Circuit decision, they cite two cases that you should look at, and I don't know if I made slides out of these, so you may just want to write this down, but or look at the Marroquin-Ochoa decision, and there's discussion of De Brenner and Zhang versus Gonzalez, Second Circuit case. And basically what those cases say is really pushing back on this categorical rule that a lot of judges are going to think categorically there's just no political opinion where you have extortion or you have resistance to gang recruitment. And for example, in Zhang, they said that the categorical rule that opposition to government extortion cannot serve as a basis for a claim based on political opinion is rejected, and instead requiring examination of the political context in which the dispute took place. And also in De Brenner, they said the careful attention to the particular circumstances surrounding the alleged persecution remains necessary, even if the persecution is categorized as extortion or recruitment. The first case I'll get to, which is the next case that relates to, that actually somebody won based on political opinion, is Martinez-Buendia. And Martinez-Buendia is a very interesting case because it's basically a 50-year-old optometrist from Colombia, and she was persecuted because she didn't give credit. She didn't give credit to the FARC, and they said, hey, you have to give credit to us because you're going around the country doing, basically helping people in their health-related matters. And then they did various things to her. Her case was denied initially, but then she won actually in the Seventh Circuit in Martinez-Buendia because they said that there was sufficient evidence that she was specifically targeted because of her political beliefs. So you really need some evidence, again, as it says, as I say here on the slide, reversing BIA's application of SEG to deny political opinion claim where the board did not analyze with sufficient particularity the facts in the record that demonstrated political motives of the persecutors. But remember, under Elias Zacharias, the Supreme Court said it's not the political motives of the persecutors alone, it has to be evidence of the political opinion of the victim that we're looking at. So let's take a look at the next slide. So remember, to distinguish SEG and EAG, SEG, these are the two cases that a lot of judges are going to point to, and you're going to need to, again, have enough circumstantial and direct evidence of that political opinion to overcome SEG and EAG. In SEG, the board said neither the Salvadoran youth who have been subjected to recruitment and who have rejected or resisted membership in the gang based on their own personal, moral, or religious opposition to gang values or activities, nor family members constitute a particular social group, and stating that respondents' argument based on political opinion is foreclosed. So, unfortunately, the board has come down very clearly, in this case, and saying that Elias Zacharias will be a touchstone for the court. And so, if the person, if your client testifies, well, I didn't want to join the gang because I was afraid, or I didn't want to join the gang because that's against my religious beliefs, or anything along those lines, or I'm afraid that I would have to do terrible things to my family as a gang initiation, something along those lines. All of those reasons are not going to be political opinion. And we'll talk in a minute about what some evidence of political opinion might be to overcome this assumption by the courts. In matter of EAG, respondents' refusal to join the gang without more does not constitute a political opinion. Now, next slide. In matter of SP, we're getting to more of a good kind of touchstone to how to argue these cases, because SP is a very important case. And it's one that really goes to the board's understanding of imputed political opinion. So in SP was a situation where there was a Sri Lankan national who was a Tamil ethnicity. He was a welder. Basically, he was taken to a camp, and then it was it was like a refugee camp. Then it was raided by the Sri Lankan army, and the Sri Lankan army then, basically held him for a long period of time, and then assumed that because he was at this camp, that he had certain political beliefs, that he was part of a guerrilla group, the Tamil Tigers, against the Sri Lankan army, where the truth was he never was part of that group, and he was subjected to abuse in terrible situation. What the board says here, again, very detailed discussion, can be very important to formulating a political opinion case, because what the board talks about here is a long discussion of how you prove motive, and the fact that there may be multiple motives, right? There could be multiple motives of the persecutor. So it's not just that the persecutor, may want you as a part of their gang, to be a gang member and carry out the duties of a gang member. That could be one motive, but it could also be to punish the person if they have expressed any political opinions, or maybe they're assumed to have these political opinions because of some relationship that they had in their life. So again, this is a really good case. I can't go through it completely. It's a long case, but take a look at matter of SP. Look at, especially on page 494, at the factors that you can use to determine the motive. There's like 5 different factors, and it talks about how you figure out whether or not there's imputed political opinion in these kind of complex cases involving either mixed motive or multiple motives. As I say on the slide, it's a good case of imputed political opinion. Asylum was granted where the applicant was detained and abused by Sri Lankan government, not only to obtain information about the identity of guerrilla members and the location of camps, but also because there was an assumption that his political views were antithetical to those of the government. And we can think about this in terms of gang cases where there's some assumption because of the status of that person or his relationship maybe to family members, or ideally, obviously, if there's any written or oral statements that were made around the time of the persecution, that would be ideal. So then the next slide is basically I've just given you the most important, what I've found in my research, other important cases that relate to resistance to join a particular group or follow their command, and in these cases the courts have found that it may be deemed political if sufficient factual support can be shown. So we've already talked about Martinez-Buendia. That's the case involving the optometrist. Remember the optometrist who is persecuted by the FARC. There's an interesting case called Jabber versus Holder, and Jabber is a case where a man was a Palestinian and he refused to join the Palestinian Islamic Jihad, the PIJ. And so he had initially lost his case, and the judge denied the case, and then he won on appeal in the Seventh Circuit because the court noted that if political opposition is the reason an individual refuses to cooperate, and that individual is persecuted for his refusal to cooperate, logic dictates that the persecution is on account of the individual's political opinion. In other words, Mr. Jabber, obviously did not want to join the gang, just like just like Mr. Elias Zacharias, he didn't want to fight, but there were other factors in Jabber that might exist in a gang case. So, for example, the evidence demonstrated that the PIJ was not simply targeting Mr. Jabber to increase his numbers, but also considered his Fatah affiliation to be in direct political opposition. So, interestingly, if you could show that your gang case has aspects of the victim, in other words, the respondent, having some sort of affiliations, maybe with the group that's antithetical to gangs, or maybe with a party, a political party, and that was able to be the deciding factor in Jabber. Mr. Jabber did not refuse to cooperate with PIJ because joining them was against the law, or because he was afraid. Instead, he refused because he was politically opposed to the PIJ, and he directly communicated that disagreement to them. So again, you're going to have to show that there's some political opposition, and to make it a stronger case, show that it was communicated in some way. And the problem we always have with our cases, as we know, is that a lot of our clients are not sophisticated enough to write an op-ed in the New York Times, and they're not going to have the persecutor sign an affidavit when they're being abused. So it's very difficult to show, but again, you want to have that connection to some political affiliation or group or political opinion. Other cases are Gonzalez and Anera, which is Ninth Circuit refuses to make payments to Shining Path. Regalado Escobar is opposition to FMLN's violence can be political opinion. And then there's a series of, I won't go through them, but a series of 10th Circuit cases that relate to Maoist. And basically, where you have direct evidence, Maoist extorted and threatened petitioner due to pro-democracy beliefs in supporting the Nepali Congress Party, where you have persecution on account of political opinion, where the petitioner involved in an anti-Maoist activity, including Save the Children or humanitarian work. Member and the last one, member of Nepali Congress Party, taught villagers dangers of Maoist Party, etc. And again, expert opinion is going to be critical to this. Direct evidence, obviously, in news articles or country condition reports or police reports or other documentation is going to be critical corroboration. So let's turn to the last slide, which is political opinion cases, some tips for everyone. Remember that persecution can be on account of the person's actual opinion, or even more persuasive sometimes when you don't have that actual opinion expressed, imputed opinion. So don't forget matter of SP, which was all about imputation, because you might have a situation where, again, somebody has a relationship to an anti-gang actor, or somebody has a relationship to a family member who has expressed a political opinion. Also look at the gang's perception of resistance. So sometimes the gangs, through testimony or through expert reports or country condition reports, there may be some evidence that the gangs themselves have politicized the resistance or expressed that in some way. So look for evidence of that. As we said before, analogize to successful claims involving, as we talked about, Shining Path, FARC, the Maoist, Palestinian groups. The reasons for persecution could change. In other words, somebody could be against, in the beginning they could be just against the organization because they don't want to engage in the activities, but then there could be multiple reasons for persecution because the person has a previous or pre-existing affiliation with another group. And so if you can show that, like in Jabber, then that's important to show to win the case. So some examples of political opinion. Unfortunately, these are not BIA precedent decisions, or even even more importantly, they're not Supreme Court or Circuit Court cases. But there have been situations where IJs have seen or allowed political opinion cases to go forward, and people have won, but very rarely. Bus fare collector in Guatemala who refused to pay MS-18 members a monthly tax was persecuted on account of political opinion. Gang members believe that woman who witnessed gang violence gave the information to the police, persecuted her on account of an actual or imputed political opinion, because, and again, this goes to perception, the gang members viewed all cooperation with authorities as an expression of political opposition to the gang's control. So, other fact patterns, a person may report gang violence to the police because of their belief in the rule of law. If there's evidence to support that, that would be really important. A person may resist gang violence because of deeply held beliefs that may be said to be political. For example, pro-government, rule of law, anti-corruption, anti-violence. Gangs that target women or girls or have sex slaves, a girl could resist based on her own beliefs about women's rights, or a gang could view her resistance as political. As I say here in the Ninth Circuit 2013 decision, Regalado Escobar, the BIA must reevaluate the position of the respondent to the violent activities of FMLN constitutes a political opinion. In its prior decision, the BIA erred as a matter of law in holding that opposition to FMLN's violence could not be a political opinion. So, what I will say in closing is that a lot of judges, I mean, I was in front of a judge not too long ago, maybe a year ago, and he said, basically some advice to my students, don't bring gang-related cases. You know, you're going to lose. Gang cases are never going to win. And I won't tell you the judge, because I don't think that would be proper, but I was appalled that a judge would have such pre-existing conceptions that are not correct. Certainly these cases are possible, again, if you have the facts to support it and you have the evidence and direct or circumstantial, as Elias Zacharias says. And the language in some of the circuit court cases are very important because they're very clear. Like, for example, going back to Martinez-Buendia, they're very clear that, and I'm quoting from the decision of Martinez, Seventh Circuit. Contrary to the government's position, Elias Zacharias does not stand for the proposition that attempted recruitment by a guerrilla group will never constitute persecution on account of political beliefs. Rather, Elias Zacharias instructs the courts to carefully consider the factual record of each case and determine whether the petitioner's fear of future persecution due to refusing recruitment attempts constitutes persecution on account of political beliefs. Elias Zacharias does not draw a bright line rule one way or the other, therefore we turn our attention to the record. So in closing, I'll just say that this is something that's a very difficult claim, but I think if you do have any possibility of making a political opinion argument, it could be the winning argument, and so it's important to make that attempt. The last page of the slides is just the credits, and I just want to publicly give credit to the kind PowerPoint that I used as a source, and also the UHLC gang-based asylum, which is a longer PowerPoint that I got some of these cases from. And with that, I guess I can take it.
So, Jeff, we have one question here, and the question is, what was the name of the brief that was mentioned to the Fifth Circuit?
The brief to the Fifth Circuit?
Andrew, do you think that's referring more to your
That may have been the
presentation?
That may have been the prior speaker.
Okay.
The prior speaker.
Okay.
Yeah.
Yeah,
Is that publicly available?
I don't think so. I can ask if we can send it out to everybody after this. I know there's a redacted version available.
Does anyone here have questions for Professor Hoffman?
I have a question a little bit more about like feminist political opinion. If you could talk maybe a little bit more about, I mean, it's mentioned in your last slide, but more about ways that you've seen that being successful, or what you think specifically would be helpful for folks maybe that don't have like a high education level in their home country, but they do have firmly held beliefs about not joining the gang as like a girlfriend or sexual slave, or not succumbing to other kinds of sexual harassment, gender-based violence.
Yeah, well, I think a lot of these claims are cutting edge. In other words, they may not have been specifically recognized in precedential decisions, but they certainly, if there's evidence to support them, there's certainly viable claims. I mean, if you have somebody who, is opposed to joining a gang because she'll be exploited, or worse, become a sex slave, and the gangs, are especially targeted to people to carry out that end. But I guess what I would say also is that it's not enough that the person has that belief. They also have to express it in some way, and they have to, like I said before, have some sort of association or affiliation or relationship that allows the gang members at least to have the perception that that person is resisting the gang recruitment for that reason. Does that make sense?
Yes. I think one of the things that's hard is that there isn't always a clear affiliation that would lead the gang to know that it was political resistance, but sometimes their own resistance, like, he has no right to my body, like that. There might be language that she's articulating, but not necessarily other affiliations.
Yeah, and I think, exactly, and I think that kind of language would have to be brought out, and it under the Real ID Act, obviously, credibility can be determined on the testimony alone, right? Unfortunately, as you know, under Real ID Act of 2005, the judge, if he or she wants to, can require corroboration. So the problem is, if the respondent, who's a woman, says, when they were grabbing me, when I was being assaulted, I said XYZ, that would support a political opinion defense or argument, that's all well and good, but the judge, under the Real ID Act, can say, well, I need corroboration. And so the question is, what kind of corroboration? Well, she's not going to have, like I said before, kind of tongue-in-cheek, she's not going to have an op-ed in the New York Times, right? She's not going to have necessarily anything in writing, but she may have affidavits from family members that heard her say that. She may have, that belonged to a church group that was against, exploitation of women. The point is, I always make this point that the three ways you can lose, and there's probably more than three, but there's three main ways you can lose an asylum case. The first is lack of credibility. The second is inconsistency, lack of consistency. And the last one is lack of corroboration. And so I guess what I would say in terms of this particular very specialized type of argument, political opinion, you're going to need a lot of corroboration.
Thanks. Any other questions from those attending the webinar or here in San Antonio? Okay, well, thanks, Jeff, for your time today, and we'll switch over to the next presentation. So give us just a minute. Our next speaker will be Justin Julius, who's going to be talking about CAT claims in a little bit more detail and also humanitarian asylum. Yeah, so that one would be... Andrea, is PowerPoint on your blackboard? Which one is that?
I don't know. I sent it to the asylum email.
Yeah.
I don't have any others. Oh, it's on top of if you wrote it, the Google Drive on the asylum email.
Folks listening remotely, it looks like we'll be taking probably a minute or two to get this set up. Just FYI, we will be back on in just a moment.
There we go.
Yeah.
On our
you already have cases for next week? You do? So, you don't have anything for the...
You're probably gonna cover one of ours.
Oh, I'm pretty sure I'm gonna be covering all of them. Or are you guys
I think
covering?
they want us to go the first
Oh,
time.
there's
so
not?
maybe, yeah, we'll be talking. I guess we'll be talking.
Well, I'll go with you guys anyway, but I thought,
I'll be in touch. Monday.
I thought that's what we had.
Like I said,
in the meeting for
we have just said we have our call.
Yeah. My office is having, this office with, one outdoors is having something tomorrow. But I guess I won't be going because I'll be on the call.
Are we ready?
There's, Asylum.
I'm not gonna confirm it. I thought it was cut.
Yeah. Especially considering these three things.
Oh, that was my bad. I thought it was cut. No, I checked that. Oh, Travis can't.
You already put them all in there?
Okay, everyone listening remotely, I think we're going to go ahead and get started with the CAT portion of our presentation. Thanks to Steve Schulman of Aiken Gump for putting this together. Unfortunately, he couldn't be with us. Something came up last minute. But we have Justin Toulis from Raices who has graciously stepped in to present the information. Thank you.
Thanks, Andrea. Hi, everyone. My name is Justin with Raices. And like Andrea said, I'm going to be covering Steve Schulman's presentation on CAT. So it's definitely his presentation, but he did leave me with a few thoughts he wanted you all to have since he couldn't be here today to frame, I think, what he thought were the greatest takeaways from there. I did want to step back just for a minute. I know that we have some folks here that have done a lot of asylum screened for humanitarian asylum, regular asylum, CAT, from our Raices offices in San Antonio and Corpus Christi, and also lawyers here in the community. But we also have folks here who may not have done too many asylum cases yet, and I think one thing that happens with asylum is that you get very much in the weeds. You know, when you look at a particular social group, it's all weeds. And I think one thing that hopefully we can do is step back in this section and talk a little bit more generally with a bird's eye view about how CAT and humanitarian asylum both get us out of the weeds. They both get us into realms of protection that make more sense to us and to our clients, particularly because, as Jeff said, our clients don't write op-eds in the New York Times. I don't think they would want to. I don't think they need to. And rightly so, that a lot of the kinds of protection we've been talking about don't make any sense. It's very hard, I think, any of us who are going to be working at the clinic or who see clients who are fleeing persecution, at least these days from Central America, it's hard to explain to an unaccompanied 15-year-old why the judge may believe everything about his claim, but he won't get protection in the United States unless he's in danger for the right reason, and that requires him to be in a group. I one time had a Venezuelan asylum seeker I represented who, as we were preparing for her case, was talking about how she used to go meet with other widows of husbands who had been murdered by the regime, and they would get together and they would talk and they would spend time. And I eventually asked her why she was focusing on that so much, and she said because I told her that to win she had to be in a social group, and it was a social group. They would get together and socialize. So the case law that I was explaining to her and the legal standards didn't make any sense to her, and I think that that is very reasonable. So I wanted to ask folks here in the room, and I know that you all online could definitely write to us here and we can see your question or your response, but how many people here have briefed a humanitarian asylum argument or a CAT claim? Okay, we have 2. Okay, great. And I think that that's also normal in preparing for this. At least here in Raices, in recent times, although we fight many of these cases, only a few of our lawyers had actually had a judge fully discuss humanitarian asylum in court and what that is even. And even as Steve Schulman pointed out, CAT claims are claims that we oftentimes don't fully prepare and we kind of see as the red-headed stepchild to asylum. So having said all that, first we'll go through CAT, then we'll go through humanitarian asylum. And I just wanted to step back a little bit and talk about, actually go back to 1939. And in that year was when the St. Louis was a ship full of Jewish folks, actually, who were fleeing from Nazi Germany. And they came within sight of the lights of Miami. And the Roosevelt administration ordered the Coast Guard to ensure that they didn't land, they didn't get protection. And the ship ultimately had to go back to Germany, where many of the passengers were murdered. And so that's exactly the kind of incident that led the world in 1951 to say this should never happen again, to set up the refugee framework that we exist with now. And that is a framework that is very much out of date in terms of who it protects, but it's not out of date in terms of the urgencies. And so I think that CAT and humanitarian asylum are ways that we have a chance to show adjudicators that, in fact, the mothers and children we work with, the unaccompanied children from Central America, these folks are just like those passengers in a ship. And that under these forms of relief, they shouldn't be turned back. They should be offered protection here in the United States. So again, CAT and humanitarian asylum are both underused forms of protection. And let's see, I'm going to try and move on to the next slide. Okay, so we're going to talk about where the requirements for both are found in the regulations at 8 CFR and some of the case law for both of them. So Convention Against Torture requires, torture. We have to show that including extrajudicial killing, is more likely than not, which is a higher standard of probability than asylum. One of the couple of things that make it a little bit harder than asylum, even though it's easier in other ways. And it's inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. So CAT is easier, again, than asylum because it provides mandatory relief for removal. If the adjudicator finds that the applicant qualifies for Convention Against Torture protection, they have to get it. There's no discretion here. If we meet our elements, the relief has to be granted, but the relief is more limited. So this is why what we all want is asylum, right? And Steve really wanted you guys to walk away with this point. Yes, we all want asylum. It's better. It's a better form of relief. But CAT is still out there, and we shouldn't give it short shrift just because it provides a little bit worse kinds of protection. So no derivative family benefits. We can't bring in family members just because one person wins CAT the way we can with asylum. No path to lawful permanent residence or citizenship. And so CAT is, in a sense, a relative of deferred action, which we talk about a lot these days, like DACA, right? And so it's something that allows you to stay in the U.S. but doesn't give you that permanent status. And then finally, it allows work authorization. So it's a form of relief, but it's limited. This has, I think, been the theme of a lot of Jeff's presentation, that asylum can be difficult in gang cases, and a lot of the presentation from Andrea and that you guys have heard earlier. Fear of gangs meets with a lot of resistance under our laws to grant protection, and we've already talked about a lot of those kinds of difficult social group framings that may well lose. So CAT requires no nexus. We don't have to show the specific reason why, let's say, a gang member or the other persecuted would target. And there are no bars. So if we have criminal bars, we may actually have bars to asylum based on things that the applicant herself was forced to do in the home country. We see that a lot with our folks. With CAT, if they qualify, we don't have to worry about those bars. They do have to receive the protection. So we have to show that the harm is more likely than not. That's higher than an asylum standard. But see, there's Rodriguez-Molinero versus Lynch case from the 7th Circuit, and that gives us some help in arguing about the likelihood of the harm. And again, as Steve points out, how are we going to show that more likely than not is more likely than a little bit less likely than not, right? And so we have a lot of room to argue and use our facts. And I think one of the other themes of this segment on CAT and humanitarian asylum is that the facts matter. I think the BIA is moving us towards facts. Our own advocacy should move towards facts, and we shouldn't be dissuaded by some of the difficult case law on classic asylum, because our facts may still get us under these two kinds of relief. We look at the totality of circumstances. So the regs lay out evidence of past torture, evidence of flagrant or mass violations of rights, country conditions, and then possible relocation within the country. We can use all of that to show that the harm would be more likely than not. I think when we look at CAT, one of the elements that's most difficult to get our minds around and figure out what we actually have to show the judge is going to be the acquiescence of the government. So we're looking at that the harm would be inflicted by or the instigation of or with the consent or acquiescence of a public official or other person acting in official capacity. What does that mean? Well, we'll talk about that in a minute. Of course, if the government is the torturer, that's fine, but a lot of times in Central America, it may be a police officer, it may be some sort of official, but what's more clear is that it's a cartel or a gang, a cartel in the case of Mexico, and then we're looking for that consent or acquiescence. So when we've got non-state actors, we want to find willful blindness or a blind eye. So that's been defined as the government looking away and therefore at least complicit in the torture by non-state actors. But we need more than just that the government cannot or will not control the persecutor. We need a little bit more than unwilling or unable, which was our standard back for classical asylum. So we don't need actual knowledge, but it's sufficient that the public official is aware of the torture of the sort feared by the applicant, that actually occurs, and that the government remains willfully blind. Under color of law is another framing of the standard that we have to prove. The acquiescence doesn't have to be necessarily an officially state-sanctioned action, but it may be under color of law nonetheless when there's a misuse of power possessed by virtue of state law and made possible only because the wrongdoer is clothed with the authority of state law. And we'll talk about how some of our case law helps us show that it can be a low-level government official. It doesn't have to be, that the Attorney General of Mexico endorses the torture. It can be that we can show a policeman in that community more likely than not would torture the applicant. So we want to talk a little bit about the Rodriguez-Molinero case, which is out of the 7th Circuit in 2015. And that's a case from Mexico. And I think it's relevant to the Central American folks we're going to be working with in the clinic, as well as for Mexico or potentially any other country. In that country, the Zetas ordered police to torture the applicant. The applicant had family members murdered. Certainly the harm was extreme. And so ultimately the applicant prevailed. There clearly we have a criminal organization that was working with the government, right? And in some cases it self-coerces the government. One official turning a blind eye or collaborating is enough. So if you got low-level officials using authority like police officers, that can make the actions under color of law. And let's think about Central America, right? We have a lot of times where the client will tell us, yes, I know that in my community the police do X. Yes, I know that they work with the gangs. Yes, I've seen the gang put a gun to the police officer's head and then them collaborate. And so we can use facts like that, even if the government comes back and says, oh, well, but the El Salvadoran government has this mano dura and we know that they aggressively take a position against gangs, but nonetheless, we could still win under this standard. Doesn't matter that the official is rogue. The 7th Circuit definitely was clearly against the IJ's analysis there. They can be acting against law or policy, but it still can be government action because that is a government official. And finally, government efforts to combat aren't enough. The question is, does it work? So in this opinion, clearly the IJ was wrong. The IJ said, well, the Mexican government is against cartels and they combat them. Well, we can prove clearly with conditions documents and our client's own testimony that combating is not effective. In many cases, it's going to be clear the harm is more likely than not, and we can prove that up through specific evidence of what our client herself may have experienced and then also country conditions. Watch out for what may happen when there's a link between the inferences we're going to make. And Jeff talked about inferring sometimes the motivation of the persecutor, which we can do. Here we may be making inferences as well about how likely the torture is. And so we have to make sure that when there's a, quote, series of suppositions, each one has to be more likely than not, and so we want to prove that up using our evidence. The key is showing the acquiescence of the government. So some clients may testify that there's active collaboration. We may see things like the police giving information to an extortionist. In one case, I worked on a case where the applicant was from Mexico and had overheard from the cartel members who were kidnapping him discussions with Mexican police officers coming through the walkie-talkie. So that's pretty clear, right? That's, I think, a little bit easier to show the link, but in other cases, we want to really probe to find out what the client knows about what's going on in her community. We definitely want to question her about what she herself knows. We can absolutely use overall conditions documents, but we want to know if she has testimony that she specifically can offer to prove up this element. And again, I think as Steve mentions, one of Steve's great takeaways, I think, in his presentation is there may be a legal standard that's a little better for us in CAT, but adjudicators oftentimes want to hold us to something higher than what we would actually have to do under the law, and I think this is one of them. I have been in credible fear interviews where the interviewer, the asylum officer, really was basing his determination on what that particular client could offer that she knew in her community. Now, I think arguably we could show this kind of acquiescence through conditions documents or an expert affidavit. but he was looking for what does she know. And so I think in our intake, that comes on to us to be creative, really talk with her about that and find out, well, did anything happen to your cousin or your aunt or anyone else you know? What do you know about what the police do in your community? Where are they intimidated so much that they acquiesce to what the gang is doing? So this is a chart that breaks down the difference, again, between asylum and CAT. You guys will have it in your materials, but I think as you go row by row, you can see where CAT can help us out, where it is actually easier to achieve than asylum. I don't want to go through this in too much detail, but I think it's a really useful analytical tool. And for CAT, I want to honor Steve as the creator of this presentation by giving his takeaway. We should not treat CAT as a last thought throwaway. If we do, we lose. We should develop it just like asylum, think about the evidence. Judges may be resistant to it because, like with humanitarian asylum, a lot of times, at least at the circuit level, those claims haven't gotten to them. Because a lot of times I think we as advocates don't develop them as much as asylum, but we should really think of CAT as an alternative independent case that's right there for us from the beginning.
Jessica, do you want to take questions on CAT before going on to humanitarian asylum?
Sure,
And
does
I can
anyone
get the
have?
presentation set
Yeah,
up for that.
that'd be great. Does anyone have questions about that or thoughts?
So CAT does not allow derivative beneficiaries as part of the applicant. So if you're looking at, just a point of clarification, like mothers who come over with their children, you would have to file a separate and develop a separate CAT claim for the children as well, is that correct?
Right, each family member would have to prove up CAT in their own right. That's true. Now, I think with asylum, one of the kinds of social groups that is more favorable to us and more cognizant of reality is family-based social groups. So, and many times we may have an asylum case for that child, for example, if we didn't for the parent. The parent may just have CAT, but the child may have a much stronger asylum case in their own right because their harm would be based on their family relationship to the parents.
Or the child might be SIDG eligible regardless still, they might have other options.
Okay, thanks. Let's see, I don't think we have any questions that are written, and I'm sorry that we can't talk to you guys like with a voice who are online, but if you have any thoughts, please feel free to write them and we'll definitely get to them while we're going forward. Any thoughts on CAT from you guys over here?
I just have a question, because you noted the one, I think it was a young lady that was kidnapped, and she heard the conversation through their walkie-talkie. So you noted all that, and you presented that to the judge, right?
Yes.
So a lot of that, we want to make sure we write it down, although it's just hearsay, I mean, what she's saying occurred. So all that is very valid, of course, but there's no evidence of it, or other than what she's saying or he's saying.
That's right, that's a great point. So, and a lot of times our clients ask us exactly that, whether it's a clinic or the kids in our shelter, they say, well, this happened to me, but I don't have any evidence. And we tell them, yes, you do. Your testimony is your evidence. And in immigration law, we're not bound by the federal rules. They're persuasive, but they're not binding. So we can absolutely bring that in. And in this case, actually, it was a pro se case that I helped on. The applicant himself, it was a man. He went forward and he won his case before the judge. I just helped him prepare the application as we're going to be doing in this clinic. And so I think it's a great example of how he told the truth, the judge found him credible, and then found that he qualified for CAT.
And there is case law that says that an applicant can win on testimony alone without any other type of document or other evidence.
Okay, so humanitarian asylum. So like CAT, this is a form of relief that can get us around some of the intricacies of what you might call more classic asylum, and I think it's a form that more reasonably recognizes the realities of the folks who are fleeing right now that we're seeing, especially from Central America. And in humanitarian asylum as well, I think it's underused. A lot of us have briefed these cases, maybe, and then even if we have, in preparing, I was talking with some colleagues at Raices, and they were only aware of 2 recent cases where, when we briefed the humanitarian asylum argument, the judge actually, in his decision, denied the case, but didn't address our humanitarian asylum argument. So those are both back from appeal, and I think it's really important to, just like CAT, include this fully as we're preparing our case and making our arguments and preserving them. So our 2 main BIA cases that give guidance on this are a matter of Chen and a matter of LS. Chen is an older case, LS is a new case. And so these lay out and discuss and call on us to really, I think, bring our arguments forward on the 2 kinds of humanitarian asylum that we have. One form looks backwards and one looks forward. So a matter of Chen is a BIA case from 1989 for the son of a Christian minister in China. His father was dragged through the streets and thrown into a bonfire of Bibles, and the applicant himself was hit with rocks, causing permanent damage to him. In matter of LS, this is a case from Albania from 2012. The applicant was in an internment camp in which the conditions actually resemble the conditions of the family internment camps that we have here in Texas, ironically. The applicant's brother's houses and store were bombed, and this was due to their participation in the democratic movement under communism. So that gives a little context, and I think as Jeff and Andrea have talked about, it's important to not be stuck with either the facts or the sort of legal framing of previous cases. We're looking to find out how they help us argue that our facts win, but that's just some context on what was going on in these two cases. So humanitarian asylum goes back to 1990, and it was then placed into the regs and expanded in 2001. It's at 8 CFR, and there's the site there. And these are the two forms of humanitarian asylum that we're going to be arguing and briefing. We are looking for compelling reasons for being unwilling or unable to return, arising out of the severity of past persecution, with the key word there being severity. How bad was what happened to the applicant in the past? Or the one looking forward, and this is the one the BIA talked about in matter of Ellis, a reasonable possibility that she may suffer other serious harm upon removal. So we have some BIA guidance on what compelling reasons are. So again, going back to the matter of Chen back in 1990, there was no well-founded fear found by the applicant of future persecution, but there was a genuine subjective fear. We had that mistreatment and that considerable harm based on what he suffered. Physical torture and psychological abuse may count when an applicant was in prison for 13 months. And then FGM in Somalia also has found to be an atrocious form of persecution that results in continuing physical pain and discomfort. The reason we thought it was important to lay these out briefly and just put the cases there so you guys could read up on them for clients that you may work with is because think about what our folks suffer that are fleeing from Central America, right? Whether it's a child or a family. How many times have we heard about physical torture and psychological abuse? Whether it be in the home, where there's maybe a domestic violence-based asylum, or whether it be by gangs, right? And I can't shoehorn my client's harm into that PSG framing, or maybe I can, but the judge is probably not going to go for that, right? They're going to deny. And yet my client was absolutely tortured and psychologically abused by her gang member boyfriend or whoever it was. So I think a lot of these framings really work for us in ways that our other case law doesn't. So aside from those, we're looking to the future. And so we're looking for a reasonable possibility of other serious harm. And that's in matter of LS. So in matter of LS, the BIA in 2012 directed the IJ to look forward and consider the second kind of humanitarian asylum that he really hadn't focused on according to the BIA. And what's required here is that we show the focus be on current conditions and the potential for new physical or psychological harm that the applicant might suffer. The serious harm does at least have to equal the severity of persecution. But look at all the things that are not required. We don't have to show atrocious of past harm. We don't have to show that the future harm would be related to the past harm. We don't need, quote, compelling reasons for unwillingness to return, and we don't need a nexus between the other serious harm and a protected ground. So that's what gets us out of all those strictures that we argue about so much with classical asylum. We don't need the nexus and we don't need the particular social group. So here we can actually tell that 15-year-old that's looking at us in the detention center, right, and saying, is the judge going to let me stay? And say, well, listen, we're going to make these arguments. If we show what would happen to you in the future and you can tell the judge about that, there it doesn't matter that you're in danger for the right reason. So again, considerations particularly related to children, and I think in the clinic we'll see, of course, moms who have children, right, and so they may have the same or maybe their own asylum cases. But in matter of LS, the BA directed adjudicators to look at civil strife, extreme economic deprivation, beyond economic disadvantage, or a situation where the claimant could experience severe mental or emotional harm or physical injury. Well, I think that intuitively that fits exactly what our clients and the folks who we work with pro se are telling us, right? They're saying, I don't know anything about this PSG, whatever framing, and it's not because of my political opinion or religion, but this is what's going to happen to me if I go back. When you look at the degree of harm, again, severity is the key, right? For humanitarian asylum, when we lose, that's why. And I think it's important to look at some case law about children, and if you guys consult some of the resources out there, there's good authorities on how what happens to a child may affect them more severely than it would affect an adult. So what isn't severe enough harm for an adult would be for a child. As I think we've talked about earlier with some of the other asylum discussions, we can use unpublished decisions to persuade an adjudicator or even be a guide to us when we're trying to prepare our case. And so one example actually that Jeff has shared in some of his trainings is a child who saw his parents killed, lived on the streets, and may potentially was an abandoned street child in Nicaragua, but even if we were to lose on that particular social group, humanitarian asylum was also relevant, it should be considered. I did want to leave you guys with another reference to CGRS, the Center for Gender and Refugee Studies out in California. And so rather than even trying to read through this PowerPoint, if you guys have a fact pattern you're dealing with, you can email them, you can find the contact on their website, and they'll send you a whole sheaf of unpublished opinions, IJ or otherwise, that will actually provide that context in a fact pattern that looks like this. Okay, great. So a few things about humanitarian asylum in the Fifth Circuit. And again, if you guys are making arguments in other circuits, please check out the case law over there because it's different. But there's really not much to look at here. And I wanted to give credit to my colleague at Raices who researched this over the summer as well. We have a case where the Fifth Circuit remanded and directed the BIA to consider whether a risk of FGM, female genital mutilation, were to grant humanitarian asylum. Okay. And we know that under a lot of our BIA case law that does work, that does warrant a grant. But there's a few Fifth Circuit cases out there that really discuss it. And that's one of our challenges, one of the reasons why I think with humanitarian asylum, we're going back to the facts, right? We're putting our facts in under the basic standards we have under, LS or Chen and the regs, but we don't have to worry about a whole lot of complex case law. We're just trying to show those basic elements under our facts. Important to raise that claim before the BIA and then also challenge that when we're appealing the BIA's denial. And of course, the Fifth Circuit has basically dismissed those arguments because that wasn't done in many cases. Severity of harm, I think, is the key. So when you look at cases where the circuit has discussed what warrants the grant, that's really what we're looking at. So you guys can check these out, really, I think, in another forum, but we've had folks who were denied because the harm wasn't severe enough. In light of the atrocities committed at the time, it wasn't particularly severe. And then again, we had what the circuit described as a speculative assertion, not warranting a grant. Again, I would look at the severity in light of atrocities. So context, I think, is really important. And I wanted to leave you guys, when we talk about this, with what the BIA itself said in LS, and that was the case back in 2015 of the Albanian applicant. And so when the BIA sent the case back to the immigration judge and said, look, you didn't do a good job here. You did not apply correctly to humanitarian asylum. You should have considered that more. That really was potentially available here. And they said that an adjudicator who's considering the second kind of humanitarian asylum, that's the one based on bad stuff that would happen in the future, the adjudicator should give particular attention to harm affecting large segments of the population, but that would significantly or more significantly affect the applicant. And the adjudicator should be cognizant of evidence of conditions in the country. And think about what the BIA is saying here. I think it goes back to some of the cases that we talked about earlier, right? Under WGR or MEVG. Those are bad for us in some ways, but they're also the BIA telling us, look at the facts. Get an expert if you need one. If you can't, go to CGRS and get one of those generally applicable affidavits from an expert that talks about conditions overall in the country. Why people situated like your client would be in a PSG. In the humanitarian asylum context, don't be dissuaded by some previous case decision, but really look at the conditions and the evidence. And look at how your particular situation, the applicant you're working with, does come in under that standard. And I think they're giving us some great ammunition if we need to really call in adjudicators to do that too. So that's all I had to say really about CAT and humanitarian asylum. Everything coming back to the facts and hopefully not giving short shrift to those two forms of protection. Do you guys have any questions or thoughts about those two things?
I guess like from a practical perspective, how do you raise a claim for humanitarian asylum in removal proceedings?
Good question. So the IJ should consider it along with your application that you filed. And I think it's also important before the asylum office, if we're filing there in the case of an unaccompanied child or maybe an adult that's not in removal proceedings yet, asylum officers absolutely consider this too. And in fact, I know in some offices they call it chin harm, after matter of chin. And LS is out there for them as well, right? So we should prepare when we brief or when we talk to our clients and frame their own declarations, we should prepare to get the officer to look at both past and future harm under humanitarian asylum. And then I think before the IJ, that's in your brief, it's in your pre-hearing statement, and important to, I think, not give it short shrift.
Can you give any pointers as to how to deal with the cartel cases, claims? Because I've been getting a lot of those lately.
Okay. Yeah, that's a great question. I would definitely go back to some of our case law here. Let's see. Oh, sorry, that was the other presentation. Okay. But I think, yeah, there's cases that help us with that for CAT, right? And so for Mexico, we're looking at that relationship to the government. And I think a lot of times it does come down to what kind of relationship we can show between our persecutors who would inflict torture and the government. I think practically speaking, and this is maybe what you've been facing, right? It's not so much that the legal standards out there don't help us, it's that our adjudicator isn't open to finding that our facts fulfill them. And so to my mind, that means, yes, we do a thorough job of showing through our own clients' testimony how the police who would torture them do work with the Mexican government. And then it's about the country conditions and the corroboration and experts if we can find them. But then it's really about preparing our record for appeal.
And preparing our clients to understand that they might need to go to a higher judge to get the result they want. I think one of the things for CAT, and this is also true for the political opinion arguments that's worth considering, is omissions. So we often think about what is the police doing with the gang. You know, are the gang walking around in police uniforms? Are the police allowing gang members to make calls to extort people and continue their criminal network from inside prison, etc.? But I think we also really need to look at omissions because there's an active duty that law enforcement, or really that a government has to protect its citizens. And when the government's failing to meet that duty, and it looks like it's just because they don't want to get involved, right? I think you can start to build an argument there that they're negligent on their responsibility. And that's true for the domestic violence cases too. I can't say I've necessarily seen that in a decision, but I think the argument could have some basis and some success depending on the facts of the case. So like Justin was saying, if you're looking at humanitarian asylum, just like anything else, you need to look at the severity of the harm, whether it's does it rise to the level of persecution, does it rise to the level of torture, or is it severe enough to merit a grant of humanitarian asylum? And then the facts on internal relocation, or in the humanitarian asylum context, whether or not that that particular individual situation, or maybe you could even say it's countrywide, might impact their ability to go somewhere else within the country. So, thinking about again, like the education, the gender, the social status of the person within that particular cultural context might make it so that if they go to another part of the country, they would face other serious harm, not just in their one town, but throughout the country.
Does anyone else have thoughts about Mexican convictions, torture, or even Central American? If anyone's argued those lately, or?
I think for a Mexican cat case, you have to have an expert. I think the problem, I lost a lot of them. But you can win them you could win them in the Ninth Circuit. The Fifth Circuit is a different thing. But the problem is that, the State Department report and all these things talk about the efforts that the government is facially making to combat the cartels, and that's what the judges rely on, right? They say, they're trying. Well, that's not the standard, right? The standard is, can they actually protect someone? And they can't protect someone. And whether or not they really are trying or are putting on a show is a real question of debate. And I think the best experts are actually people in Mexico who have a lot of experience in human rights issues. And I have someone whose contact information I can send out who I've used before, who has a lot of experience with human rights issues, who just told me that she's available to take on some more cases. So I can send that to the Carnes Pro Bono. I can send her contact information. But I think without expert evidence, even though there's so much evidence about how bad the violence is, in all of those reports, there's also evidence about what the government is doing to try and fight back, and that is what I've seen over and over again get used by the judges to justify, either that they can go somewhere else, or that, you know, there are good people in the Mexican government that would protect them.
We've been seeing that even like in IJ reviews of credible fear, negative findings for El Salvador and Honduras and things like that too. So not just for Mexico.
And I had a merits case in Honduras that part of the judge's finding was that the government was trying to protect her because there was a law against rape, which I think is a complete misinterpretation of the legal standard. But
Right.
you know, you get those decisions, so get on the record for appeal.
Yeah, and I mean, look at the language in Tapia Madrigal, which is a Ninth Circuit case, which again, you know, the judges are gonna roll their eyes here, but those are the arguments that you wanna make, right? That it's not, are they trying? It's, the standard is, are they actually able to protect? And so it doesn't matter how many millions of dollars are being spent to combat drug violence. The facts are, more people are getting killed, you know, this year than in the past. It is getting worse. And so no matter how much money they're throwing at the problem, they're not actually able to protect people who are targeted.
So Eric, I have a follow-up question for you on evidence. So if it's not possible to get an expert and work with them, you know, by having them review the case, provide an affidavit or testify, have you ever succeeded, or do you have recommendations for what you can do short of that? Have you had success with some of those sort of generally applicable affidavits that we've seen a lot in the family detention context or other conditions?
I've never won a CAT case with just like an affidavit that wasn't specific to my client, but I think it could be possible.
Mm-hmm.
If it's more up to date. And I mean, then I think the other kind of evidence that you really want to, that's more persuasive, is not hounding so much on the things by Human Rights Watch and Amnesty International, but what's in the actual State Department reports, and then looking at documents from the UN human rights mechanisms have issued some really, really scathing reports regarding Mexico. And so I think those international bodies are maybe more palatable to judges than Human Rights Watch or Amnesty International, or you could also look at some Mexican NGOs send basically like a shadow report. So when Mexico is being reviewed, for example, for under the UN General Assembly for their human rights practices, the government has to send a report. Well, Mexican NGOs have been sending their version of the report for many, many years, and they're very good and they're very different from what the Mexican government reports, and you can find those online on the UNHCR website. You can search by country to find documents, and you can search by mechanism. So you can, if you're doing a CAT case, you can just look at the Committee Against Torture, or the Special Rapporteur Against Torture, and see what documents they have recently. And because the situation in Mexico is so bad, there actually is a fair amount of recent information. And when you have a UN body saying that they're not meeting the obligations of the Torture Convention, that's pretty strong. And try and highlight that kind of evidence, because they are a party to the same convention that we're trying to use to save our clients, right? And so when the body says they're not complying with it, that's a problem.
So if there's no other questions, we probably should wrap up. We're a little bit over time. The next panel starts in 20 minutes. There is a great resource called refworld.org, and lots of different international organizations will post reports there. And also I would recommend the Inter-American Commission on Human Rights.
Did you say ref or ref?
It's REF, so R-E-F, for refugee. So it's
I felt like either one.
R-E-F.
It's a real world.
Yeah.
And I think the site's actually maintained by the UNHCR, but
Yeah.
they don't sponsor the content.
And what was the second one you said there?
And then the Inter-American Commission on Human Rights and Inter-American Court, They do a lot on issues like impunity and government responsibility, which I think can be helpful for some of the CAT arguments as well as other issues. They have a repertoire of migrants and women's issues. So. So then you go ahead and sign that.
Judge, my client suffered rough treatment.
Right.
It wasn't persecution, but it was
If anyone that needs a parking validation from me, and if anyone hasn't checked, and most people have, but I have packets up here. I don't think so. I think you just put that one in when you go out, and it should let you go out. Of course. So this two very practical and important topics. One is how to work with survivors of trauma, and the second is how to write a strong asylum declaration. So first off, we're going to turn to Bernadette Solorzano, who works at Our Lady of the Lake University and has definitely some experience with helping asylum seekers as well as other victims of crime here in the U.S. And others with both their next steps in journeying on in life, but also she's helped us at Raices, and I'm sure she's helped many others in the community with expert declarations. So I'll turn it over to Bernadette.
Thank you very much. I'm really happy to be here, and I am also happy to be available if anybody needs any consultation and talking to clients after this, because this can be pretty quick. I'm more than happy to respond to emails, set up a time to talk. I'd be glad to be supportive as you guys get your sea legs under you. I think one of the most important pieces that I wanted to really share with you is, I think I've seen over the years is there's a certain, culturally, I think that as Americans, we have a very difficult time putting aside preconceived notions about what we think is going on in other countries. And so I think that it's very important to approach each of the clients with a sense of cultural humility, be curious about what their life's experiences were like. It's going to be a piece of the joining and winning the trust with and building your client-attorney relationship with them. Especially someone who has been in a situation where they fled for their lives. So you know they've got a strength somewhere in their core because they left. They survived the journey. They got here. And so you need to hold that sense of respect and convey that to your client, so that you also, when you do that, you're also, as a white woman, an older white woman, I can't tell you how many people from different countries have said to me, it's amazing that you really genuinely seem to want to know, and you don't treat me in a way that makes me not feel safe with you. Feeling safe with you is going to be extremely important, and they're not going to tell you all the things that you need to know if you don't spend the time building that trust. You could start from a very small point, like some of their favorite things. You know, who are they as a person? What has their life been like? Ask open-ended questions. Invite them to really expand on their story. It's amazing, especially with younger people and people maybe who have just had less life experiences outside of their own area of the world, that they can really expose you to some things that will help you really help their case, just because you kept yourself open and not knowing and asking open-ended questions. So that was, is it stuck? Okay. Yeah, so, and don't understand too quickly. If they tell you something, they answer a question, there may be more that they're not telling you. So even if you think you understand, ask them to expand on it. This is a well-used therapeutic tool, and I can't help but think it would be incredibly helpful for attorneys when they're trying to get a client to really give them information that can help their cases. You want to really be careful to not show your emotions on your face. You don't want anything they tell you you don't want to look horrified by some of the terrible things that you may hear, because that may shut them down, because then they may go into self-care mode, that they can't share these things with you because either you're thinking badly of them or they're upsetting you. And so you really need to continue just to invite them to tell their story. So I have a kind of a both-and attitude about trauma. Some people have only lived in an area where there's been nothing but really one traumatic event after another, really challenging things. But it also, you have to take into consideration, I worked a long time with children who were very ill, were born with birth defects or needed an organ transplant, and they were always sick, and so they had a lot of resiliency because they didn't really know any other way of living their lives. And so when things got bad, it went from they were dealing with they were dying. And so I think people who live in a prolonged traumatic area, that's something that they've learned a lot of coping, and they found the strength to finally leave. The family's gone around them. So there's post-traumatic stress, but we need to take into consideration a sense of hopefulness for these people, because there's also post-traumatic growth. We don't know why it is that some people respond resiliently and don't go into a post-traumatic stress disorder, and it may be the way that they've been asked questions, the way they've been treated. With our jobs, when we're trying to help them to seek asylum, we have to do a both end, because we have to prove hardship and we have to prove risk, we have to prove danger, but we don't want to do it at the risk of re-traumatizing, further traumatizing the individual that we're trying to help. And that becomes really big when I'm doing the psychosocial evaluations, working with adults and children and teens. And one of the things I always invite them, and you guys feel free if you feel this is not something that fits in the legal arena, but I always tell them that it's very important for them to tell me as much as they can remember. And we can take breaks, we can pace ourselves, but that we're taking something bad that has happened in their lives. And they're digging deep into their strength so they can share this with me, so we can help make something good potentially happen to them because of what they've survived. So you're laying this out as they're taking control of their lives. So you're not keeping them in a one-down victim sort of state. Because they're the only ones that can give you the information that will help you fight to keep them here. So you really want to convey that sense of empathy and respect. So if you find somebody, watch their body language. If you find they're getting tense, or you're finding that they're on the verge of crying, you might even change the subject and ask them something that's not maybe case related, and kind of get them to calm down a little bit and then go back to it. Pacing is going to be really important. If you find yourselves getting overwhelmed and emotional, it's okay to take a break for you. Self-care, when you work case after case after case of really difficult things, or when I was listening to somebody over here saying that they'd lost a huge number of certain asylum cases, that's going to wear a person down, that you've worked so hard, you've done your research, and then you've got a judge and a government attorney that is not understanding what you are trying to convey in your case. And I know I had a judge ask me once, what causes depression? If I knew that, I wouldn't be sitting here. It's like I have no idea what causes depression. But I was trying to help him understand, because he was catching this poor woman out with confusion of dates, and everybody who does this work knows trauma survivors have a really hard day with sequential remembering. They have a hard time with dates. And so it's not that they're lying, it's that they lived in a state of chaos for so long, that wasn't important for them to necessarily remember. And memory is a creative process. We don't necessarily always remember things exactly the same. How many of you guys grew up with brothers and sisters? And do you find that you guys have different memories of the same events within your family? It's like I always wonder, where was I when all this was going on? Because I don't remember like that at all. So that's also important to remember when you're writing your cases.
Do you find that it affects their memory now?
Yes. Yes, it does. It can. It doesn't always have to. I had a client who was so traumatized by what she had survived. It's a horrific story. It started at age 13. But when she came in, she was probably the most traumatized young woman I've ever seen. She could not remember her address where her brother lived. She could not remember a phone number. She literally could not remember anything. After we worked with her for a while in therapy, she was becoming more stabilized. But and that was a huge piece of the case that I really needed to speak to the judge, because he could have taken it as if she was lying.
I guess I was wondering about whether they remember things happening now. So like if you're having a client who has trouble, making appointments on time, is that because they're...
It could be.
Okay.
Yeah. This client we had to call her an hour before her appointments to get her, because she was too overwhelmed to remember things. It doesn't necessarily be a rule of thumb, because everybody's different, but it can happen. And that gets frustrating too, when you're trying to work with a client, they keep no showing and they have transportation problems and things like that. That can be a huge frustration, and so you have to kind of put yourself in the mindset that you're working with somebody who is one, living in a constant state of uncertainty, not knowing if they're going to be able to remain here or to leave. They could be dealing with detention. I had a client who was in detention in Houston, and she had tried to commit suicide, but she had never told her attorney some of the things she had gone through. The first person she shared some of her trauma was with us. I don't know why that was. She had a male attorney, and maybe she was embarrassed and ashamed, but I think male attorneys can definitely get female clients to share with them if you join well with them and convey a sense of respect. I don't think it has to be gender matched particularly. It just depends on how you handle the interview. Should I? Okay. Trusting somebody in authority, that's big. So that's another reason why you have to really join with them, because they've been caught at the border. We have no idea how they've been treated when they entered. They may have surrendered, but we've all heard the stories about being held by the border patrol, and then being moved into a detention center or in a comfort reminding shelter or the family detention centers. And all those stories are pretty heartbreaking. So if then you're coming in as the attorney, why necessarily should they just believe you that you're there to help them? Because they may have come from a country where you couldn't trust anybody and everybody was, was telling on everybody else. So in terms of in with the gang and they were spies, so you've got to earn their trust. And how do you do that? You be honest with them. You try and take your time with them. You are curious about them. You reassure them about client attorney confidentiality. Do you guys have exceptions to confidentiality in the law profession, or is it airtight? You have some exceptions as well?
Yeah, if someone says they're going to kill someone or kill themselves, I think there's an exception, or harm a child.
So it's the same as in both fields?
Probably pretty similar.
Yeah, okay. And of course, in psychology, Texas is a permissible state to tell if somebody's going to commit a crime or kill themselves, but it's not mandated. And so you can still be risking outcrying for somebody if you're a psychologist or a mental health professional, which I think is really rude, but anyway. But I'd still do it in a heartbeat. Yeah, so respectful, being sincere, taking care of yourselves, being sure that you're not showing that, you really need to be careful of being too sympathetic. And you don't want to be too much of a cheerleader because it comes across as a little artificial or fake. And so it's why I keep saying you really need to be genuine with your clients. Okay. All right. One of the things that is a challenge for me, and I think it would be a challenge for you guys, and I talked about this a little bit before, is how not to reinforce a sense of brokenness of the person, even though we really need to build a strong case for them. There needs to be a little bit of underlying, it may be hard for you to hear this, and you may not believe me, but I'm impressed that you were able to make your way here, and you're still fighting to find a way to stay here. So you want to plant seeds of support, of the strength that you see in them, but you'll want to put it up in a way that they can't argue back with you. It's like, you may not be able to hear this, you may not even think that I understand, but this is what I'm seeing. And that'll continue to reinforce that sense of trust between you and the client. Do you guys ever work with families, or do you do each one individually? Each person in the family individually?
I know I work with families.
Okay.
And I think probably some other people here do too.
Okay. So working within the system, the whole building some of those strengths in the interview, how did they get here as together? How they make the decision as a family? Because that may give you information without directly going at the specifics about what happened to you. By inviting them to tell you the story of what they did together as a family may give you a lot of information you might not get with direct questioning. Does that make sense? I think that's pretty much everything, except I wanted to ask if anybody had questions. Oh, yeah. So I mentioned the term cultural humility at the beginning, and I defined a little bit about that. But what do you guys think would be an example of how you would be culturally humble with somebody coming from another country and outside of your experiences? Anybody have any ideas?
Acknowledging just the differences between your reality and theirs.
I think also just admitting that you don't know what their reality is. And so you're counting on them to be able to share that with you.
Absolutely. It's essential so you can help them. Absolutely.
And also showing, I think, curiosity about their culture.
Absolutely.
You know?
I will often ask, what's important for me to know about your cultural experiences that will help me build your case? And I'll invite that into the conversation. What's important about your spirituality or your religious beliefs that will be important to me to help build your case? Being curious about different aspects of their lives. I was just, and I could do this at the end as well, but if anybody has any questions that they want to ask, I'll be glad to be open to those later. I don't want to take up all your time.
I mean, there's plenty of time.
Awesome. Should we swap places?
Okay.
So should
Yeah.
we be here?
So give us just a moment, and we'll get the next PowerPoint set up. One of the things for asylum cases that ties into what you were just saying, Bernadette, that I found to be helpful is because there is a balance, right? You don't want to look like you're, at least as a young female attorney, totally incompetent, that you have no sense of what they're going through. But you don't want to also put all these assumptions based on something you read in another case.
Mm-hmm.
So sometimes what I tell people is, please help me write your statement. I can only write, even though it might be obvious to me and to the judge and to everybody else, I can only write down what you are telling me. And that also helps sometimes elicit testimony when they might otherwise think something's obvious. So it ties in a little bit.
That brings up one more thing that I meant to say and I didn't. How many times do you guys will have to work through a translator from somebody who speaks a different language, like Hiche or some other language?
Sometimes, yeah.
Well, one of the things I think is important is it's like you're juggling two things. You're having to juggle the client, and you're also having to juggle the translator. It's very important that you have a translator who understands that you need to hear what they are saying, not their general rephrasing of what they're saying, but you need to hear their words. You may have to work with the translator or send the translator to therapy afterwards, because it's like when we do that, it's like sometimes you've got a translator who's been upset as well as the client. But it's very important to educate your translator that they must be accurate with their translations. I had somebody once who kept cleaning up my client's language because she was saying curse words, and it's like, I need to hear her curse words, so. Oh, he had his way with her. He raped her.
Well, with that, let's turn it over to Erica Schumer. She is works at St. Mary's Law School here in San Antonio as a clinic faculty supervisor there. Has a lot of experience with asylum law, so she's going to talk to us about writing declarations and some tips on how we can make sure that we're getting a good story down, an accurate story, and not missing something crucial for the case.
Thank you. So declarations are super important, and one of the things in working with clients is that in the very beginning, if you're going to sit down and start writing a declaration, you need to tell the client why you're doing it and that it's really important, because they may just think like, why are you asking me all these questions again? And it takes a long time to write a good declaration. Unless you're in Carnes where you don't have any other options, it generally does not happen in one sitting or two or three. And so you need to explain that. It's really important to get your story down, and we're gonna meet a lot of times until I understand everything that happened and we can find a way to present this to the judge. Credibility in asylum cases is everything. After the Real ID Act passed, now any inconsistency can be used to support a negative credibility finding. It used to be that only inconsistencies that were material to the claim could be used to support a negative credibility finding, but that's not the case anymore. And so it's really, really important that the declaration is solid, that there's not inconsistencies. And another reason why it's so important is that if the judge or the trial attorney or the asylum officer is going to read anything before the interview or the hearing, it's going to be the client's declaration. And so if you have a sloppy declaration that raises a lot of questions, or it just sounds like, oh, well, this is just another gang case, the adjudicator is going to walk into the situation already prejudging that this is not a good case, and already with this idea of like, oh, I'm going to have to sit through this 2-hour hearing listening to this person who doesn't have a claim. So you want to present a compelling story that's really going to grab the attention. And you know, with a trial attorney, if you have a really good declaration, sometimes they'll agree to limit some of the testimony your client has to give if there's really, really bad, for example, sexual violence. They may not make them tell every single painful detail of it. So it can really work to your advantage. No, yeah, sorry. I think for people who are new to asylum law, before you sit down with a client, it's a good idea for you to kind of outline what the issues are that you need to cover, so that you're thinking about the topics you need to cover. And you know, in some cases, you might not have a 1-year filing deadline or a firm resettlement issue, but if you do have one of those, you need to kind of know enough about the law to know what facts are important to try and get from your client to see if there's an exception to the 1-year filing deadline or why firm resettlement shouldn't apply in your case. If it's at all possible for you to review the notes from a CFI or an RFI or the I-589 before you do that, it's really going to help you because you're going to have a general sense of some sort of the timeline and some of the basis of the claim, and you'll be able to, you still have to check to make sure all of that is accurate, but it's going to help you where you're not just starting from absolutely no information. And it's going to make it a little bit easier for the client because you can say, you know, I see you told the asylum officer that on July 15th the police went to your house and arrested your son and he was held for 3 days and tortured. I need to ask you some more details about that. But at least that basic stuff she doesn't have to tell from the beginning. In talking about who drafts the declaration, there's various things to consider. A person's ability, so are they literate in a language that you can translate? It is really important to capture a person's voice, and so it's not super common that I have had clients who write their declaration, but some people can do a first draft, and when you get that kind of first draft, it really, I think, does make a declaration that is more in their voice. And so if you do have somebody who has the literacy capabilities and the time, you could give them some prompts and say, you know, I want you to see if you can work on writing down answers to these 5 questions, and then you at least have something to start. You should not just say, write me a declaration of all the bad things that happened to you, because you're not going to get anything probably useful, because that's just a very daunting thing, I think, for anybody to deal with. And you know, even with very literate clients, if time is of the essence, it just might not be feasible for them to take the time to write something and then for you to work on it. So how do we get the information we need? Again, it's really important to explain why you're writing a declaration and why it's so important that everything in the declaration is absolutely positively true. You need to tell people that it's okay to answer a question with I don't know or I don't remember. I think that, you know, there's this expectation that if you're asked a question, you should answer the question, and saying I don't know is not an answer to the question, but the reality is a lot of times you don't know the answer or you don't remember, especially if it's with respect to a date or when something happened. And so you need to let them know that if you ask them a question, particularly with a date, they absolutely should not guess, and they should tell you that they don't know or they don't remember. You want to ask open-ended questions. And going to dates, you have to be very careful. I am super reluctant to put specific dates in declarations unless my client is absolutely certain that that's the date. If they're guessing, they're like, well, it's July 1st. Like, why do you, I will actually ask them, why do you know it happened on July 1st? And sometimes the answer might be, well, I know it was at least in the end of June because my mom's birthday is June 20th, and it was after my mom's birthday, but it was before something else. Well, you know, and sometimes clients will say, that date is engraved in stone in my mind because of what happened, and I will never in my life forget that date. Fine, we're putting it in the declaration. And a lot of times, especially for clients who suffered some sort of abuse over long periods of time, they really don't know. And then you need to do the prompt questions of like, well, did you have children? You know, or if it was something that happened when they were a child and they have 5 siblings, like were all 5 of your siblings born? Were you in school? What grade were you in? To try and get approximate time frames and kind of piece things together. You want to be as specific as possible. So something that would be very typical to get in the beginning is a response like, how did your husband treat you? He abused me all the time. He insulted me constantly. And generally, clients don't want to give you more than that, right? Because giving the details, what you see in the revised draft is stuff that people don't want to talk about. So how do you get from the first version to the second version you see on the slide? You know, what do you mean by abuse? And it's, well, he hit me. Well, how did he hit you? What did he hit you with? You know, where did he hit you? And he hit me with his hand. Was his hand open or closed? I mean, very specific questions like that. And then, what does all the time mean, right? This is a very common thing, constantly, all the time. What does that mean? How often? On average, about how often did it happen? Insults with the verbal abuse. Most of our clients do not want to repeat those words. They don't want to think about them, and a lot of times they are the swear words that they don't use, and it is very important for you to say, unfortunately, I need you to tell me the exact words that so-and-so said to you. You're not going to offend me. You're not going to offend the judge. We've heard these words before, and we know that these aren't your words. We know that you don't, you know, we're not expecting that this is the way you would talk to a judge. And give them the space that it's important to use that exact language. And so that's where you start to get the details that you need. And you know, this takes a lot of time. The first meeting with a client, it maybe is not the time to ask all of these follow-up questions. The first meeting you might want to get a big picture kind of idea, and then the next meeting you're going to start breaking down these different incidents. So for domestic violence cases, if you're dealing with someone who was in an abusive relationship for a period of years, it is impossible in a declaration to give a chronological narrative of every single time that there was verbal, physical, or sexual abuse. I think it's really important to cover the first incident because normally that is clearly ingrained in someone's mind, the worst incident, and then the last time that there was physical violence. And you may want to do the same, for example, if there was sexual violence, you know, when's the first time it happened, what was the worst incident of sexual abuse, what was the last time. Also, people tend to remember abuse during pregnancy, so that would be a specific question. If the person has kids, you know, were you ever abused in any way during your pregnancy? And of course, I hear myself right now saying abused, and you really shouldn't ask people, were you abused? Because that's a word that has a lot of different meanings. So if the answer is no, then you can ask follow-up questions. Were you hit? Were you slapped? Were you pushed? Were you threatened? Because that can mean different things to different people.
Would you say, Erica, if the client uses the word abuse, that at that point you would be okay to use that with the client, or would you still stay away from it as a general rule?
I think you can use it, but before I would say what I would definitely ask, when you say abuse, what do you mean? So that I think that I have an understanding that it, like, is that covering only physical abuse? Is that covering sexual abuse? Is that covering verbal abuse? And then try to go from there, if that makes sense. With sexual abuse, I don't ever ask people if they've been raped, because I think that for a lot of people that has a rape is someone is physically holding you down or tying you up and very violently raping you. And our definition of rape is much different. And so I find it a lot more useful to ask, did you ever have to have sex when you didn't want to? Did you ever have to do anything sexual that you didn't want to do? And you know, part of doing this process is also educating your client and helping to prep them for their testimony. And it's important to explain that in the US, if you are forced to have sex with your husband, that's rape. And because you might have, a trial attorney might ask, you know, were you raped? And your client might say no, because again, their definition of that word is different. So there is a kind of educational process of, you know, when in our culture, in our society, rape includes, you know, any kind of forced sexual contact. And that's, you know, preparing them for things that could end up hurting them if they don't understand that in the hearing. And a recent case that we did in the clinic, I mean, our client, it took a long time for her to wrap her head around that. I mean, the first couple times that she was like, well, he didn't rape me. I was like, wait a minute, you just told me that, you know, every 2 weeks he would come home at 2 o'clock in the morning and demand to have sex with you, and you didn't want to have sex with him, but you did so that he didn't beat you. Yeah. It's like, okay. Here, that's considered rape, and you know, so she did well in the end, but it was not one time. It was many times until she could kind of deal with the concept that what had happened to her, that she could answer the question yes if she was asked with the word rape in a hearing. Another thing that's really important is identifying who your client is talking about. So there is this, you know, tendency to not use anybody's name, or to, you know, the story is so personal to them that they're don't always realize how difficult it is to follow. So, you know, some delinquents attacked me when I was walking home. Well, who were they? I don't know, right? And does the person know the people? No, they aren't people that she knows the names of and can say, yes, I know their name and I know where they live. But then you ask the follow-up questions to figure out, like, oh yeah, she didn't know them, but she knew that they were MS gang members. Mm-hmm. And, you know, these, if you're talking about a gang attack or a criminal, attack by a criminal group, or attack by the police, or attack by soldiers, you know, how many are we talking? When you say they, does that mean 2? Does that mean 12? It's important to flesh out those details. And that's something that really is going to help them with their interview or with their hearing, because the judges and the asylum officers go nuts when people are he, they, and sometimes you really can't distinguish, because they might be using they to refer about gang members, and then they're also referring they to refer about police officers who they're trying to get help with, and it really is confusing. So try to find a way to, in the declaration, identify whoever you're talking about with as much specificity as possible. So if it's a gang and they know the name of the gang, use the name of the gang, use the number of people. And if it's a person, an individual they actually know, use the person's name. Make sure you set it up in the declaration, but it's much more easy to follow with names than it is with just these general pronouns.
And I would just add to that that your work in preparing the declaration also prepares people for court, right? So you want to encourage them and explain why you're asking them to not just say they, and tell them that to try to remember to do that in court as well. It's not natural. We don't always, every time we refer to somebody, say that person's complete name. But I think we need to start working with our clients as soon as possible to get them ready for court. That includes answering questions directly. Sometimes we get clients that just will not answer a question directly, and they need to know that it's okay for them to say whatever they think is most important, but they should answer our question first and then add whatever else, so that they can start to see how they need to talk to the judge to avoid confusion, adverse credibility findings, and just pissing the judge off. There's a couple other things too that come up when you work with interpreters, in terms of the person not pausing enough or not knowing to ask for clarification if they don't understand a question. So all of those court skills for your client's testimony you can start building when you start the declaration. And when you explain, I find it really helpful when you explain that this is helping them in preparing for court. I feel like they tend to pay more attention to me when they understand what the reasoning is behind what I'm asking them to do.
So you want to explain action and inaction. So we have assumptions, and judges have assumptions based on their experience. If something bad happens to you, you go to the police, you ask for help, you leave an abusive situation. And so that's what's going to be going through the judge's head if the judge just reads the first thing. I didn't make a report because I was scared, right? Well, why were you scared, right? And in this case, when you look at the revised draft, you realize that actually this person had a really good reason for not going to the police, because her neighbor who went to the police after getting the same threats ended up cut up into pieces in a bag, on the street. And so that is much more compelling, right, than just being scared. Well, what were you scared of? It's important to elicit as much information as you can to try and educate the adjudicator about why their response was actually perfectly reasonable and justified. And it wasn't them just, it wasn't that, oh, well, it wasn't that bad, because surely if it had been that bad, the person would have done something, right? So questions that are important to ask to try and develop to get to that second draft is, well, why didn't you report? I was scared. Well, what did you think would happen if you reported? I thought they would kill me. Well, why did you think they would kill you if you didn't report? Because they threatened to kill me. Do you know any cases where the gang actually killed someone for reporting? Yeah, it happened to my neighbor, and she was cut up on the street. Well, suddenly that makes a whole bunch of sense, right? So, but you have to go through, again, all of those steps to try and get that information out. And so as far as the inability and unwillingness to protect, prior experience is the best. So, well, why didn't you go to the police after your husband cracked your head open? Well, the first 2 times I went to the police, they laughed at me and told me to go home. If you don't have the prior experience, that justifies why you didn't do whatever thing the judge might assume you should do. Personal knowledge. Well, my sister went to the police when her husband beat her up, and they, insulted her, didn't help her, whatever. Or then if you don't have personal knowledge of someone similarly situated, you heard from a neighbor about what happened to her sister, or you heard it from the news. So you have to, some explanation about why it's reasonable for the person to think that the police wouldn't have helped. And then you want to try and explain nexus. And I think that this is sometimes the most difficult part, right? You ask them, well, why do you think the person did this to you? And many, many, many times the answer will be, I don't know, right? And so you need to try and find the questions of getting context, right? So a lot of times when you ask the follow-up questions, you find out that right before, during, or after the incidents, the person who's doing the abusing is actually saying the things that give you the reason why they were being abused, right? But you have to ask those questions. And if, you know, I think what's really difficult, like at Carnes with a lot of the gang cases, is that it is a lot more difficult to find the nexus thing, so you have to ask a lot of questions of trying to look at characteristics of the person you're talking to. Like, okay, well, you said that they found you at your business. Were there other people with similar businesses who were also targeted? Or, you know, if it's a woman who is single, does she think the fact that she's single and there's no man living in the household, does that have anything to do with it? And just ask a lot of questions about their situation to see if you can find any connections. Or it turns out that, oh yeah, you know, all the women in my family had X happen to them. Well, okay, that tells me that that's a possible reason why this may have happened to you. And, you know, you have to be a little bit difficult, because you can't, I think in situations like that where you can find a pattern of similarly situated people, yeah, there's going to be some question in court, right? Like, well, how do you know that? Well, you can't know, usually people don't know 100% why something happened, but you could say, well, the only thing I can find in common with the other people who I knew went through the same thing is X. And then you have your evidence about nexus. Ask as many questions as you can until the story makes sense. If something does not make sense to you, it is not going to make sense to the judge. It is not going to make sense to the trial attorney. And you can't think like, that seems really weird to me, but I'm just going to leave it there because if I didn't give you a good justification. I mean, sometimes I end up just taking certain things out because I just can't, it's so strange that I can't wrap my head around it. Usually you can get to a point where it will make sense, but sometimes it takes a long time. You need to address difficult issues in the declaration directly, and ideally as early on in the affidavit if you can, if it doesn't screw up the organization. So if the Border Patrol statement says that they said they weren't afraid and that they came to the US to work for 3 years, like almost all of them say, you need to address that. Either I told the Border Patrol agent that I was afraid, but we had a case recently where our client really did say that she came to work. She also said she was afraid. Of course, the working part was in there, the fear part was not. But you need to address that stuff. If there was stuff that they didn't disclose to an asylum officer in the credible fear proceedings or on their I-589, you need to talk about why they didn't disclose it. If you know, it's trauma related, that they just weren't ready to share that yet, it's really helpful if you can get an expert. And as to the unreliability of Border Patrol documents, I actually have some reports here from the U.S. Commission on International Religious Freedom. They just issued a report in August called Barriers to Protection, and it documents massive problems with Border Patrol interviews. So that is something that you may need to attach to your evidence packet if you have a situation where the Border Patrol statement that you have just does not match up with what your client says happened and what they told. And that's for people who are watching after the fact. You can find it online. It's called Barriers to Protection. And that's a good, helpful thing to use. Your job really is to help the person, help shape their story, right? So it is really important that you're using their words, that you don't write it as a, you know, legal piece. You need to try and give some sort of organization to the story, particularly if you have a person who has been harmed by different people for different reasons. It's really helpful to use headings and kind of talk about, you know, Ms. Garcia was abused throughout her marriage, and then Ms. Garcia was abused because of her political opinion, and so that the adjudicator can kind of keep the things can think about different sources of harm, and that it's well organized, particularly when you do have people who have been harmed by multiple people over many years. You can end up with a really, really, really long declaration, and so it helps to have headings and things like that. The more detail you can give, the better, as long as you think that the client is going to stick with that level of detail, right? So again, if you're working with a client who's really traumatized, and sometimes they give a lot of details, and sometimes they don't, and sometimes they're okay with dates, and sometimes they're not, you need to be careful about how much detail you put in a declaration, because even if you have a psych eval and someone to testify, the judge still might have credibility concerns if it's somebody who really has a hard time telling their story because of trauma. Don't use language that the person wouldn't use. So maybe you've seen some medical reports that talk about lacerations. People don't use that word generally, right? People don't generally talk about harm as persecution. One of my pet peeves when I review declarations is using would all the time. He would beat me. He would say this. He would do that. That's colloquially how we talk, but really would is conditional, right? So only use it if it's conditional. If it's that he beat me often, then he beat me often, or used to do whatever, or just use the past tense. Don't draw legal conclusions, so a declaration shouldn't say, my fear is credible, my fear is subjectively reasonable. People don't talk like that. That goes in your brief, right? But not in the declaration. Don't include information that's not relevant to their protection claim. So if it's an asylum claim, don't put in there that they are so happy that their child is going to have these great educational opportunities in the U.S. That is not relevant to their protection claim. You know, don't put in there that they wanted to come because their Aunt Betsy, you know, has lived here and they haven't seen her for 15 years and she's the favorite aunt. People don't go on this journey and come here unless they have to. And so putting in things like that, you know, I want to give a better life to my kids, is going to be used against them, right? That really you admitted that you came to work. You admitted that you're here because you couldn't afford to have your child in school. And your child's in school now, right? Yes, and isn't the school wonderful? Yes. Don't give them that information.
And what do you do when you think the client might testify to that?
I think you have to explain the law, and that, you know, while you understand that that's one of the benefits of coming, that they're only going to be able to win their case if they prove that they meet the criteria for asylum, and that while it's admirable that they want to give a better life to their child, that's really not relevant to their claim. And I think that, you know, at the end of the day, if you think that at some point that's going to come out, you can practice some questions with them that you might be able to do on redirect. Like if we're talking about the aunt, well, you said your aunt, you know, has been living here for 15 years, right? Yes. So why didn't you come to reunify with your aunt before 3 months ago? And then ideally the answer to that is not because I didn't have the money to cross, right? The answer to that is because I didn't have any other choice to, you know, I had to leave to save my life, or to save my child's life.
So a somewhat related question, when I've reviewed some of the declarations out of Carnes, I've seen this happen a lot, but I've also, in certain circumstances, done this in my own declarations, which is adding things that might not be directly relevant except for purposes of discretion. So positive factors about, you know, having these children, or other things that they might have suffered that don't go directly to the claim. So when, if to any degree, would you include things that might not be directly relevant that could potentially help as positive discretionary factors?
I think, well, one, I think for most people who haven't been here before, who don't have any criminal history, discretion is not an issue, right? The people who are going to get denied on discretion are people who actually have, 4 DUIs or other problems, right? So if I had a client where I thought there's some sketchy history, we do need to have information about discretion, then I would put that in. And then I think the stuff about the family, you want to try and you can kind of spin in a way that isn't contrary to the protection claim. So, my children are the most important thing in the world to me, and if I'm dead, nobody will be there to take care of them. So I am asking for this protection so that not only for myself, but so that my children will be able to study and be and live a life free of harm or something like that, right? So you kind of you are talking about how important it is to them, or you might frame it in that if it were that maybe they wouldn't have gone through the whole journey, like maybe it would have been easier to just let whoever kill you, but I left because I didn't want to leave my children in that situation. So you can still kind of talk about the family. And then, I think it's also different, like if you have a child who has serious medical needs or educational needs where they really were not being met, I don't think it's unreasonable to put something in about how, the U.S. is such a great country because my son is finally able to do something that he couldn't do there. But I think you have to be
Has that ever worked
careful.
against you? I'm asking because that was something when I was working at transplants for children. The family brought their daughter over in a hepatic coma. She needed a liver transplant. And I raised $250,000 for her to get the surgery, and she was transplanted. But immigration was saying she couldn't stay because she was going to be a drain on the system. And so she unfortunately died, but so we'd have to fight it out. But
yeah. I think it could be if they're not U.S. citizen children. Yeah. So I think it's different. I think, and where I think you can definitely mention the kids is when you have people who were released whose cases have taken longer. Their U.S. citizen children certainly do have rights here, and then the idea, especially, the older they are, that children who have really no recollection or experience or language skills to be in a country are going to be much more vulnerable to some, especially if we're talking about Honduras, right? You put a 12-year-old boy who barely speaks Spanish and has grown up in the U.S. on the streets of Tegucigalpa. People are going to know that he doesn't really know how things work, and that's going to make him vulnerable to being harmed. Again, like I talked about, just don't put anything in there that doesn't make sense to you. And just kind of some things when you're reviewing the declaration, when you think you've got everything, look again. Is it internally consistent? Is there anything that within the declaration that's contradictory? Then look at the other evidence you have. Is there anything that is contrary to the I-589, to the notes from the CFI or RFI, to the Border Patrol report, to country conditions evidence, to an affidavit you have from a family member or a friend, to police reports, medical reports? All of that stuff has to match up. When there are things in the declaration like, oh, I went to the hospital, or I went to the police and did this, or I talked to these people, you have to be thinking and asking the questions like, can I get that corroborating evidence? If you can't get it, you better be prepared to explain why you can't get it, what you tried to do to get it. Because otherwise that can actually end up under, even though credible testimony should be sufficient, right? There is this duty to provide corroborating evidence when you can. And then reading back the declaration, so assuming that you're writing it and or really, have revised very heavily what a client wrote, even if you have had 10 sessions and been verifying things as you go, it is extremely important that you read back the entire declaration from beginning to end in one sitting, which is a pain. Nobody wants to do it. The client doesn't want to have to sit and listen to it. But it is so important, and it is important that you don't treat it as in like, okay, before you sign this, I have to read this back, so I know we've gone over this 100 times, but I'm just going to read it back to make sure that everything's right, okay? That is giving a message that everything I wrote here is correct, and you're going to nod your head and say yes, okay? You need to say at that point, I know we've talked a lot. I know I've asked you a million questions. This is the most important thing that the judge is going to look at in your case. We have to make sure that everything is 100% correct. I'm going to read this back to you. If there is anything that is not exactly right, stop me, tell me. We're going to fix it, and then we will be done. Because that conveys the message that this is really important. Again, for most people who are seeking asylum, they have never worked with a lawyer before. As we project our assumptions on them, they are also projecting their assumptions on us, and a lot of those assumptions are, you're a lawyer, you know what to do, you know what to put on the paper, you know what's going to help my case. But like Sarah said, we should only be writing what they're telling us. Unfortunately, sometimes we get it wrong or misunderstand things. And so it's really important that they know that it is their story, and that if there's something that's not exactly right, we didn't make it that way because that's better for their case. It's just a mistake. And it's important to fix it. Because otherwise you're going to get yourself in a situation where you have errors in the declaration, it comes out in the testimony, and then the judge is going to say, well, I see on the declaration of certificate of translation that says this was read back to you, and you said it was right. Was it read back to you? And it's like, well, yeah. Well, why didn't you say that anything was wrong? And this actually happened in one of our clinic cases. And, the client just said, like, I didn't feel like it was my place. I thought, he was my lawyer, and I felt like I shouldn't make him change something.
And maybe, Bernadette, you might be able to address this a little bit, because I've had clients express to me, luckily before we got to court, but that they didn't want to tell me something like a bad word or they didn't want to share anything because they were nervous and they were afraid of my good opinion being lost. And I think that really comes up when we review the declaration, because they often are uncomfortable, I think, correcting attorneys, even more so correcting the judge, and again, training them to get ready for court. Do you have any tips?
I think doing exactly that is to setting the table. It's like everything, this is what the judge is going to see, and if there's anything that we can add to make this more powerful, that you remember as I read this, maybe a bad word or another incident, or I've made a mistake, and mistakes are they're going to go against you, not against me. So you need to be my full partner in this and making sure that this is as accurate as you can possibly make it. And I think you just need to join. And that's what I do when I read back the biopsychosocial evaluations with the clients. And I tell them, if I've gotten something wrong, you need to tell me, because everything has to be completely correct, or it's going to blow up in our face. And so then they'll correct me. You left out the name. Or you spelled that wrong. So I would just partners with them.
One thing that I think also can be useful, although I don't think this would be sufficient, but after reading the first sentence or two or the first short paragraph, saying, was there anything else that you wanted to correct in there? Did it all sound good? And kind of establishing that you really are willing to listen.
Yeah, if you read the whole document without stopping, they're not going to stop you. That's very important. You have to stop at the end of, I think, each paragraph and say, how how's it so far? Just what you said, I think that's really important. I think another thing that sometimes has to be taken into consideration when you're preparing someone that has to speak up for themselves. I had a woman from Central America who, she was 64 years old. She'd always lived by herself. She'd never married. She lived near family. Somebody would bring her stuff and she would make baskets and things, and then someone else would sell them. So she was a very isolated life. And so when she had to testify in court, she would not answer any of the male judge's questions. She was terrified of him. And so he denied her case because she said she wouldn't even speak up for herself. But when no one had done an evaluation on her. So when I was doing my evaluation and her niece was with me, I was getting all of his background information. And so then I was able to probe, so how is it for you talking to men? How is that for you? And then it all came out, so then I was able to put that in the evaluation, and they requested a change to a female judge, and she got to stay.
Right, so if you're reviewing a declaration, you're seeing the client's body language indicating that maybe they're not paying attention, because maybe they're worried about their kids getting picked up from school or or whatever the case may be, you know, checking in and seeing how they're feeling about the process.
Absolutely, absolutely.
One thing that I forgot to mention earlier on that I thought I was going to mention is just talking about accuracy, making sure that names of place, like names of people and names of places are actually accurately spelled and make sense. When I'm doing declarations, like I'm constantly looking on Google to like look up if like, does this city exist? And they're saying, yep, it's 4 hours from there. And I'm like, really? And especially, you know, in Central America, you look on a map and you think, that doesn't look 4 hours away, but, you know, it's a dirt road. So, in fact, when you put in driving directions, it's 4 hours away. And sometimes you might want to put that kind of stuff in your pre-hearing statement, in your country conditions evidence, if it's important, right? Because if you're thinking, that doesn't sound right to me, the judge is probably going to think the same thing. And so use that evidence and check that stuff. And especially for clients who have very little education, you asking them how to spell a place is probably not the best way to check if it's actually correct.
Yeah, I think you can put a disclaimer too, either verbally or perhaps in the declaration or somewhere else in writing, because with illiterate clients or even not, often places have more than one spelling, and the client might say Sevilla, but we say Seville, and the spelling's different. And so I think making the judge aware of those issues up front is really important. Related to that, I was actually going to ask you a question about when a client's using a word and we don't really know how to translate that, either because there's not a direct translation or maybe there's multiple translations. Do you have some tips for how to deal with that?
Yeah, you have to ask them. I think that's something that I should have talked about, that even if you're fluent in the language, don't assume that like what you think that word means is really what it means, especially if it's important. So for example, we had a case recently where the client, in Spanish said that his father beat him with a lasso. And, I said, well, what do you mean by lasso, right? And in this case, the family had a store and it really was a lasso used for animals, right? But a lot of times I've heard lasso used, as a rope, a belt, a cord, and that, especially if it's an object that was used to beat or torture or do something, that can kill your credibility, right? And it really could be that you just made an assumption and used, the word that you would pick to interpret lasso, when really there are options. And so
and there are different words that mean different things in different countries.
Exactly. Yeah. And so,
there's a term in Mexico for candy, I can't remember the word now, that means something completely different in Central America. And when one of my clinicians was working with, doing therapy with a client, it was like, she was horrified that she had said this word, and she's like, what does it mean in your country? And it was something really insulting.
Yeah. Yeah, so it's really important to make sure that, to just check back and be like, do you mean this, right? Just say what you're understanding and you're knowing in your head how you're going to write that in English, and make sure that that's what the person means. Because the problem, like, with lasso in that case is like, you heard it from the client, so when you read it back, you're going to say lasso because you remember that that's what the client said, but that doesn't fix the problem that there are 3 different options in English that you could use.
And sometimes you might actually, even if you do get a correct translation, in that case I would think want to explain it, the context about them having the store and all of that, because the judge might look at this and be like, that doesn't even make sense, this guy's obviously making up his story.
Right.
So I think we're at time. Does anybody have any questions? Well, I'm going to go ahead and end the webinar. And thank you to both of you for being here today.